The Auctioneer Commission meeting to order.
I'll do roll call. Bobby Colson.
Here.
Ronnie Collier.
Here.
Adam Lewis.
Here.
Jeff Morris.
Here.
Howard Phillips.
Here.
You have a quorum, sir. At this time, I'll read the notice of meeting. This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since October 1st, 2014. This meeting was also noticed on tn.gov's website. Yes.
All right.
Well, now I'll turn it over to Ms. Kropp for the rulemaking hearing.
All right. This rulemaking hearing is called to order. My name is Julie Kropp. I serve as staff attorney in the Department of Commerce and Insurance, Division of Regulatory Boards, and serve as attorney for the Tennessee Auctioneer Commission. Would the agency representatives who are present introduce themselves for the record of the rulemaking hearing? And that's just the 5 of you, and I know you just did roll call, but if you don't mind doing it again for our transcript.
Bobby Colson. Jeff Morris.
Howard Phillips.
Ronnie Collier. Adam Lewis.
It is Monday, October 6, 2014. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated, Section 45204, in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Tennessee Auctioneer Commission is proposing to update certain existing rules relating to topics such as the duties of an auctioneer, non-auctioneer on firms, civil penalties, and notification of change of information, and to create other new rules relating to escrow account requirement, livestock auction sales, online auctions, and military applicants. The Tennessee Auctioneer Commission is proposing these rule amendments and new rules because the Commission has identified the need to further clarify certain provisions of existing law in order to better protect the public health, safety, and welfare. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room. Only those who have signed in will be permitted to speak. The notice of this rulemaking hearing, including the entire text of the proposed rules, was filed with the Secretary of State and published in its Administrative Register website on June 24th, 2014. Ms. Whaley, what additional notice was given to the affected individuals or groups?
Information regarding the rulemaking hearing, as well as a link to the full notice of rulemaking hearing, was sent via electronic mail through the use of the Notify app on July 2nd, 2014. The entire text of the proposed rules was included in the Newsline Summer Newsletter 2014, which was posted on the Tennessee Auctioneer Commission's website on July 2nd, 2014, mailed by U.S. Mail on July 9th, 2014, additionally disseminated via email by way of the Notify app on July 2nd, 2014.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will read the substance of the proposed rules into the record. The amendment to Rule 0160-01-.01 entitled Duties of the Auctioneer is amended by numbering the existing paragraph in that rule as paragraph 1 and adding a new paragraph 2, which shall read as follows. The new paragraph 2 will read, "No licensed auctioneer shall accept offers for hire to call bids at any auction held by an auction house, auction barn, or auction gallery that is not either A, owned and operated by a licensed auctioneer holding a valid firm license, or B, licensed as a gallery pursuant to the provisions of TCA Section 62-19-125. The Rule 0160-01-.05 publication of name is amended by deleting the phrase name of sponsoring auctioneer and the auctioneer in paragraph 2 and replacing it with the phrase name of its principal auctioneer and the principal auctioneer. So that as amended, the paragraph shall read, all advertising of an auction sale by an auction firm not owned by a licensed auctioneer shall include the name of its principal auctioneer, and the principal auctioneer shall attend all auction sales. Rule 0160-01-.11 Civil Penalties is amended by deleting the text of the rule in its entirety and substituting instead the following language. And I will not recite the entire rule, but the substantive changes to that rule are to add civil penalties for a number of defined of sections, including 62-19-125 A and B, as well as comment that the subsection stating that each day of a continued violation under paragraph 1 may constitute a separate violation. Rule 0160-01-.14 fees is amended by deleting paragraph 6 in its entirety. Rule 0160-01-.16 non-auctioneer firm license application is amended by deleting the name and text of the rule and substituting the following. Paragraph 1 is a non-auctioneer owned firm is an auction firm which is not owned in any part by a person who holds a Tennessee auctioneer's license. Paragraph 2, every application by a business entity, including a limited liability company, corporation, or partnership, not principally engaged in the auction business for an auction firm license or license renewal, shall designate as the applicant a natural person who is an employee, owner, shareholder, partner, or member of the entity and meets the applicable requirements of TCA Section 62-19-111. The designated applicant shall be the individual responsible for the firm's license. Paragraph 3, a non-auctioneer owned firm must also designate in its auction firm license application one licensed auctioneer who shall serve as the firm's principal auctioneer. The principal auctioneer shall attend and along with the firm shall accept responsibility for all auctions conducted by the firm. Paragraph 4, any non-auctioneer owned firm must notify the Commission within 10 days of the death, resignation, termination, or other extended absence of the firm's principal auctioneer. The firm shall have no longer than 30 days from the death, resignation, termination, or other extended absence within which to replace the principal auctioneer and must immediately notify the Commission in writing of the auctioneer's replacement. The firm shall not conduct any auctions until the Commission has received its designation of a new principal auctioneer. Rule 0160-01-.24 entitled Notification of Change of Information is amended by adding the following language as a new paragraph 2. Any firm must notify the Commission within 10 days of the death, resignation, termination, or other extended absence of the firm's principal auctioneer. The firm shall have no longer than 30 days from the death, resignation, termination, or other extended absence within which to replace the principal auctioneer and must immediately notify the Commission in writing of the auctioneer's replacement. New rules include 0160-01-.26 entitled Escrow Account Requirement, which states all licensed auction firms and galleries shall maintain an escrow or trustee account for all funds that belong to others but which are held by the firm or gallery as a result of an auction sale. New Rule 0160-01-.27 entitled Livestock Auction Sales, which states 1. Pursuant to TCA Section 62-19-103-8, the provisions of Title 62, Chapter 19 do not apply to any livestock auction sale regulated by the United States Department of Agriculture, Packers and Stockyards Administration if the sale uses A, the shipper's proceeds account required by federal regulations, and B, a Tennessee licensed auctioneer. Paragraph 2. Any operator of a livestock auction sale that is not registered with and regulated by the Packers and Stockyards Administration shall not qualify for the firm or gallery license exemption under TCA Section 62-19-103-8 and must be appropriately licensed. Paragraph 3, if the owner of a livestock auction sale that is registered with and regulated by the Packers and Stockyards Administration sells any items other than livestock at a regulated livestock auction and the proceeds are deposited into a shipper's proceeds account, then neither a Tennessee auction firm nor a Tennessee auction gallery is required. Any such auction must still be conducted by a Tennessee licensed auctioneer. Paragraph 4, any person acting as an auction firm or gallery outside of a livestock auction regulated by the Packers and Stockyards Administration shall hold a Tennessee auction firm or gallery license and is subject to all statutes and rules of the Tennessee Auctioneer Commission, notwithstanding such person's registration with the Packers and Stockyards Administration. Paragraph 5, nothing in this rule shall be construed as exempting any person acting or advertising or representing to be an auctioneer or apprentice auctioneer from the licensure requirements of TCA Section 62-19-102. New Rule 0160-01-.28, online auctions. If the time for an online-only auction with a fixed bidding time is extended beyond the online auction's fixed ending time, then the auction and the person conducting the auction are not included within the exemption specified at TCA Section 62-19-103, and the statutes and rules of the Tennessee Auctioneer Commission shall govern the online auction. New Rule 0160-01-.29, entitled Military Applicants. Paragraph 1, an applicant for licensure meeting the requirements of TCA Section 1304D1 may A, be issued a license upon application and payment of all fees required for the issuance of a regular license of the same type if, in the opinion of the Commission, the requirements for licensure or other such state are substantially equivalent to that required in Tennessee, or B, be issued a temporary permit as described herein if the Commission determines that the applicant's license does not meet the requirements for substantial equivalency, but that the applicant could perform additional acts, including but not limited to education, training, or experience in order to meet the requirements for the license to be substantially equivalent. In that case, the Commission may issue a temporary permit upon application and payment of all fees required for issuance of a regular license of the same type, which shall allow such person to perform services as if fully licensed for a set period of time that is determined to be sufficient by the Commission for the applicant to complete such requirements. 1. After completing those additional requirements and providing the Commission with sufficient proof thereof as may be required, a full license shall be issued to the applicant with an issuance date of the original issuance of the temporary permit and an expiration date as if the full license had been issued at that time. 2. A temporary permit shall be issued for a period of less than the length of a renewal cycle for a full license. 3. A temporary permit shall expire upon the date set by the Commission and shall not be subject to renewal except through the timely completion of the requirements for substantial equivalency as required by the Commission or by an extension of time granted for good cause by the Commission. 4. Should an extension to a temporary permit cause the permit to be in effect longer than the renewal cycle of a full license, then the holder of the temporary permit shall file a renewal application with such documentation and fees, including completion of continuing education, as are required by the Commission for all other renewals of a full license of the same type. Paragraph 2. Military education training or experience completed by a person described at TCA Section 1304D1B2 A through C shall be accepted toward the qualifications in whole or in part to receive any license issued by the Commission under the Division of Regulatory Boards if such military education training or experience is determined by the Commission to be substantially equivalent to the education training or experience required for the issuance of such license. Paragraph 3, renewal. A. Any licensee who is a member of the National Guard or reserve component of the Armed Forces of the United States called to active duty whose license expires during the period of activation shall be eligible to be renewed upon the licensee being released from active duty without 1. Payment of late fees or other penalties. 2. Obtaining continuing educations when I. Circumstances associated with the person's military duty prevented the obtaining of continuing education credits and a waiver request has been submitted to the Commission, or II. The person performs the licensed occupation as part of that person's military duties and provides documentation sufficient to demonstrate such to the Commission. 3. Performing any other similar act typically required for the renewal of a license. B. The license shall be eligible for renewal pursuant to the subsection for 6 months from the person's release from active duty. C. Any person renewing under this paragraph shall provide the Commission such supporting documentation evidencing activation as may be required by the Commission prior to renewal of any license pursuant to this paragraph. At this time, I would like to make the notice of rulemaking hearing, which contains the entire text of the proposed rules, and exhibit to the record, please. you have comments for the rulemaking? Okay. At this time, we're going to take comments on the proposed rules, and we have 4 written comments. 2 of those written comments were submitted by individuals who are here and are also on the list to speak. It's up to the commission whether you would like to take the written comments first, and then those folks that are also here can come up at that time and read their comments and expound if they'd like to, or we can take the verbal comments and then take the remaining written comments at the end. It's up to you all how you'd like to do that. We just need to address anyone here who would like to speak, and then there's 2 additional written comments that I don't believe the individuals are here today. The written ones first? Okay. As well. And I believe you already have the comments from Ms. Hanson, correct? Okay.
If we have written and also you are here, is it not duplicating to do the written and then you do then they speak?
What I was going to do is for the folks that are here that have written comments, I was going to ask them if they'd like to come up and read their written comments to you all themselves, and then that way if they'd like to add anything verbally, since they've made the attempt to be here as well, they can read what they'd like and then verbally go through that. So we'll handle those at the same time. I'll start with these in the order that they were received, and the first one is dated September 3rd, 2014. There's a heading on it that says John Hoagland Auctions at the top. Have you all been able to locate that one? Okay, I'm going to start with that one because it was the first one I received. It's September 3rd, 2014, State of Tennessee, Department of Commerce and Insurance, Tennessee Auctioneers Commission, 500 James Robertson Parkway, Nashville, Tennessee, 37243, 1152, regarding proposed new rule 0160-01-.26 escrow account requirement. To whom it may concern, I know that the rulemaking hearing is not until October 6th. I know that the rulemaking hearing is not until October 6th, but I'm very curious into the scope of the new escrow account requirement rule and what date it will go into effect. In approximately December 2000, I closed my escrow account with permission from the Auctioneer Commission. Since that time, I've worked exclusively as a contract auctioneer for several licensed auction firms in Tennessee and Alabama. I have not had the occasion to handle funds that belong to others and do not intend to. I have even referred some decent auctions to these firms to avoid the associated hurdles. If I am required to open an escrow account, it is my intention to never make a deposit because I do not intend to handle funds that belong to others but which are held by the firm as a result of an auction sale. The Tennessee Real Estate Commission has a form called Request for Waiver of Escrow Account. I'm enclosing a copy of said form for your consideration. If I have to open a dormant escrow account, it will not be the end of the world. However, I feel like I might not be the only auctioneer with this particular concern. If the rule passes without any concessions on October 6th, please let me know on what date it will go into effect. I don't want to break any rules now because I'm almost home. Thank you in advance for your help. Thanks again, John Hoagland. Now,
You want to comment on that?
each person that comments, what's required by statute is for the commission to respond to that comment and state either the reason for accepting or declining to make the changes suggested in the comment. This comment, the way I read it, boils down to this person asking if there's any room for any kind of waiver for someone such as him who does not hold any funds, or if it would apply equally to that kind of person.
As you read the rule, it says all licensed auction firms and galleries, if you're operating as an individual auctioneer, it doesn't require it, does it? Am I reading that incorrectly?
I've got it right here.
If he's inquiring as to auctioneers, I don't think that rule applies.
Well, I imagine that he, like all the other licensed auctioneers we have, does have his firm with a, it does have his auctioneer license associated with a firm. I believe he does. He has to have his firm, his auctioneer license tied to an auction firm. So I imagine he has a firm of his own.
No, without looking up the record, but I mean, I think what we're trying to say here is an auction firm or gallery. And I don't know that the waiver would go away if the waiver is still part of the rules that we're allowed to issue a waiver or not.
When he first contacted me, I don't have any record in our rules or our statutes allowing a waiver. I told him I was not with the commission in 2000, had no knowledge of any waiver he might have gotten, and did not, advised him that any comments that he wished to make to the commission, because I just couldn't speak to something I wasn't aware of.
That predates me as well. Is anybody on the board familiar with that rule?
Waiver of an escrow account? I mean, why would he know?
Well,
He didn't pull this form.
That's for the real estate commission.
It's
He's giving it.
I got you.
I think that
Which reading is not a bad
I think
deal.
this rule is a pretty fair rule for everybody, and I think everybody ought to have an escrow account if you're an auctioneer. And if he's associated with this firm, did you say he is associated with the firm?
Yeah, everyone's license has to be tied to a firm. Now, he may not be conducting auctions on behalf of that firm. I don't know what his business model is. To me, it sounds as though maybe he's, and correct me if I'm wrong, you all may read this differently, it sounds as though he's contracting with other firms to just call for them, and that his, although he's probably the principal of his own firm, his firm is not the one actually running the auction. However, I don't know that for sure. All I have is what I've read to you all. This rule you all was something that you all wanted, because we have a similar provision in the statute for non-resident auctioneers. I believe it's actually drafted very closely, if not identically.
Well, I
to
don't
that
know
provision.
this. I don't know this gentleman, but I like his attitude. He said if it was necessary, he would go ahead and open up his account.
And so you all,
The other question I have is, once these rules are adopted, what would be the effective date of them?
it's 90 days after filing with the Secretary of State, but the process after today is that once I get the transcript back from the court reporter, all of the comments and your responses to the comments are summarized in a different form, similar to this notice of rulemaking form, but it's a different one. Once I get that and am able to prepare that form, summarizing the comments and responses, as well as any changes that you all might choose to make today as a result of the comments, that information is prepared and sent to the Attorney General's office, and they do a final review of legality and constitutionality of the rules, and then the Attorney General will then sign off on that form of the rules. There's no exact time that I can tell you it takes, because it's not within my hands of how long it takes the Attorney General's office to approve those. But once that's done, as soon as I get it back, it would go straight to the Secretary of State, and from the date it's filed with the Secretary of State, it's 90 days from being effective at that point. So there would be at a
That's
minimum.
after it goes to the Attorney General.
Right.
and all
Correct.
that.
The Attorney General has to sign off
So
before
this
that's.
is not going to happen tomorrow.
No, sir. Most
right.
definitely not.
Someone would have time to get them an escrow account or whatever they needed to do.
So I guess, would you all's response be in line with what Mr. Phillips stated of basically, thank you for your comment, but our position is that you should have one, whether you hold those funds or not? Would someone be willing to make that in the form of a motion? Just so
I'll
we
make that form of a motion that we respond back to Mr. Hoagland's letter and tell him that we appreciate his comments very much, but we're going to hold fast to the rule.
and that he would need to have an escrow account to be in.
Motion made, how about a second?
Second.
Motion's been made and second. All in favor say aye. Aye. Motion carries.
Okay. The second comment we have, and I believe this person's also not here, please correct me if I'm wrong, Miss Tamara Russell. Okay. It's an email. You'll see at the top, it's got my name at the top. It says from Tamara Russell. It's dated Sunday, September 14th. Do you all see that? Okay, first it says, Dear Ms. Crop, thank you for bringing my comments before the participants in the October rulemaking hearing. Most sincerely, Tamara Russell. The body of her comment is as follows. To whom it may concern, I recently received a copy of the Tennessee Auctioneers Commission newsletter, which included the notification of rulemaking hearing. While reviewing the proposed amendments, I noticed that within the very first part of Rule 0160-01-.01, subsection 1, it reads, The auctioneer shall be responsible for the advertising and management of the sale and account for all proceeds therefrom, and shall over his signature, and then it contains an ellipsis. I understand that this portion of the rule is not being considered for an amendment, but I would like to request that in the future the Auctioneers Commission would consider an adjustment in the wording to include the female gender throughout the rules. Using this instance for an example, at that point where the notation is for his signature, would it be possible to change the wording to read his/her signature? I realize that there are not as many women auctioneers as men licensed in Tennessee, but it would be wonderful to be recognized even with that tiny change. Thank you for your time and consideration. Most sincerely, Tamara Russell, Principal Auctioneer, Childs Ford Auction and Real Estate Company. As you can see, if you look to page, let me see, it would be page 2 of your notice of rulemaking hearing. She's referring to that first rule that's duties of auctioneer. The reason why she was recognizing that that subsection is not open for amendment at this point, as you will see in the notes, that that rule is only being amended by adding a number 1 to that existing paragraph that she's referring to. The real substantive amendment is adding the subparagraph 2, which deals with another matter entirely.
I think her point's well made, and we need to be mindful of that. Although, like you said, that's not part of the rulemaking that we're making.
I think in the future, if you put
Their
auctioneer's signature, it could be either.
And I believe, if I'm not mistaken, all of the new language that we have today is gender neutral, unless I'm mistaken. If you all would like to make a motion that any language that's within this, within the rules that we're making today, if there's any gender specification, and include that. But I don't believe that subsection 1, and certainly not other provisions of the law that aren't herein, are open for changes today.
This is not really anything we can do anything about today.
No, and I believe she recognizes that. She's just asking for that.
I move that any part of this rulemaking hearing that we have today be gender neutral.
Second.
Been moved and second. All in favor, aye. Aye.
Aye.
And do you all, I don't, it's my opinion that this particular subsection 1 is not open by this, but is that okay. Anything else, though, that's in here we'll look at. All right. The next written comment that I have is dated October 6, 2014, and it is from Copart. It is signed by James R. Hines. Mr. Hines is here today. He is third on the list to speak. And then the last written comment that I have here today that I received this morning is from, I don't know if it's signed by anybody, but it's from Nashville Auction School. And I know Mr. and Miss Hanson are both here today, and they're both signed. Well, Miss Hanson signed up as fourth to speak. So we can take Mr. Hines as first if he'd like to come up here and read it, and then if he'd like to supplement it. Mr. Hines, it's up to you how you'd like your comments presented to the commission. I'd be happy to read what you have, but if you'd like to supplement anything at all, now would be the time to do it. They've asked to take written comments and the oral ones at the same time. So. You can go ahead if you'd like to read it to them. They've got a copy of what you have. It's up to you how you'd like to present to them, because you've made the effort to be here today. So,
For the record, my name is James Hines, and I'm the Director of Government and Regulatory Affairs for Copart. Copart is a leader in the salvage auto auction business. We offer a range of services for processing vehicles and selling them over the internet through our online auction technology platform. And we are an online auction only in selling these cars. We sell these cars on consignment. The consigners include insurance companies, banks, rental car companies, fleet companies. And we also sell vehicles for dealers, franchisers, independent auto dealers. And then lastly, we also sell to the general public. First rule I would like to address is the proposed amended rule 0160-01-.24. This is the rule that changes the notification provisions for notification of a principal auctioneer who has left a firm, whether it's due to a death, resignation, termination, or some sort of extended absence. Under the current rules, notification is 60 days. For notification of an auctioneer who has left a firm, and the proposed rule would change that to 30 days. And I would like to comment that that period is too short when you consider the hiring process in today's market and the time that it takes to post a job listing, to review applications, interview applicants, conduct background checks, and make final offers to ensure that you get the right person. That takes a lot of times more than 30 days. So Copart's recommendation to the commission that you would allow 60 days to replace an auctioneer for a firm, which is current law. And I'll gladly take any questions on our comment to this proposed amendment to the notification rule.
Why don't you just continue on with your other comments, and we can kind of address them all to do them one.
All right, thank you. My second comment is regarding the online auction exemption, and this will be related to proposed rule 010-01-.28. The Commission has taken the position in the last 3 years that an extension of bidding time in an online auction does not allow that online auction to claim the exemption. So basically it takes the auction out of the exemption. And Copart is in favor of the current law the way it is written. Back in 2006, when the legislature passed, it was HB 3507 to provide the exemption, it was clear that Tennessee was taking a hands-off approach to online auctions. And that was to allow free market benefits to flow from Tennessee to online sellers, buyers in Tennessee, and elsewhere. And by doing so, by reducing barriers to entry for online auction companies in Tennessee, this has resulted in greater consumer choice with regard to online auction and retail services. So at the heart of the Commission's interpretation is how to interpret the phrase any fixed price or time listings that allow bidding on the internet website but that do not constitute a live auction. The Commission's interpretation of that rule is that it applies to fixed price or fixed time listings only, but Copart's interpretation of the rule is that it applies to fixed price listings or time listings. And under our interpretation of the rule, a simple extension of a bidding time for a listing, or by the same token, the reduction of a bidding time for a time listing is still a time listing, and it should still qualify for the exemption under the rule. And so that we recommend that the Commission not adopt the proposed new rule because it would be inconsistent with what Copart sees as the plain reading of the exemption statute as it currently reads today. In the alternative, if the Commission concludes that the proposed new rule is not inconsistent with the current exemption, then we would recommend that the Commission not adopt the rule today, but instead make a legislative recommendation to the Tennessee legislature to incorporate the proposed rule into law. And by doing this, sending it to the legislature, this will give all stakeholders an opportunity to design a policy and a rule that balances all interests. In reviewing the newsletter of fall 2011, the Commission addressed the online auction exemption rule, and this was with regard to penny auctions. And by implication in that newsletter, there was concern about consumer protection with regard to penny auctions. I would urge that with regard to consumer protection issues, there is a myriad of state and federal remedies that are available to deal with the issues that may come up with regard to online auctions, particularly with regards to fraud. The Federal Trade Commission and several state attorneys general have engaged in crackdowns on internet auction scams. The Tennessee Attorney General has addressed this issue, in fact, addressed drop-off auctions in the spring of 2006 as the Tennessee legislature was debating the online exemption rule. And I think that the Tennessee Attorney General will continue to be a watchdog with regard to consumer protection surrounding auction issues. And so I merely put that in there to state that the furtherance of consumer protection is not necessary with the adoption of the rule. If you do not adopt a particular rule, there are plenty of legal remedies available for potential victims of an online auction. So in brief, those are my comments. My written comments are a little bit more detailed. I'm happy to entertain questions.
Thank you very much, Mr. Hines, but if my memory serves me correct, this online auction has already been to the legislature and it's been passed, and the Attorney General was the one that ruled that an online auction has a beginning time and an ending time. That's the difference between a live auction and an online auction. And it's been controversy, the best I recall, since it started, because people doing online auctions, as long as they wanted to, could continue that auction. And I think that the Commission's idea is, if we're going to do an online auction, let's have a beginning time and an ending time.
And I certainly respect the Commission's position. When we look at the law itself, and when we look at what the current rules, there's nothing that says in the law or in the Commission's current rules that an extension of time, and by the same token, a reduction of time for a time listing takes an online auction out of the exemption if they are claiming the exemption. Let's go back to 2006, and one of the basis for getting the online exemption is that we're talking about an automated trading platform, a marketplace where buyers and sellers can come online and engage in the selling of goods. It's all automated software. There's nothing about an overtime bid button or a buy it now button on a time listing that takes that and makes it more of a live auction than not. And it's still the same automated software. It's just another feature that's been added to the listing. So I guess I'm trying to understand, what is it that is so special about the extension or a reduction of time, because you would have to find that a reduction of time would also take an online auction out of exemption. I'm trying to understand, what is it about having that automated software feature that the implication, it becomes more like a live auction, therefore you lose the exemption.
Thank you for your opinions, but we disagree.
Sure, respectfully, we disagree.
Is that you all's response to his comments on proposed rule 0160-01-.28 regarding online auctions?
Well, as I understand your comments, there's two issues that you have. One is the 60 days versus the 30 days for replacing the auctioneer, and then secondly is about the online extended time taking you out of the exemption for getting a Tennessee auctioneer's license.
That's correct.
Okay.
Yes.
I mean, the 30 days, we came up with that because that more closely resembled the Tennessee Real Estate Commission's rules, and we were trying to align ourselves more with those rules. And I think we were trying to streamline that. Personally, I think if you can do it in 60, you can do it in 30, would be my response to that. As far as the online part of it, we do have a big difference of opinion as to how you get an exemption under Tennessee auctioneer law. We're not in favor of extending those or expanding those exemptions, in my opinion.
We need to rule on this.
Well, if
That
you,
one chance to respond.
I would just like to clarify what the commission was stating. If you all, in response to your question, Chairman, if you all are in agreement with Mr. Morris, he seems to suggest that he is in agreement with making a motion to change the provision regarding replacing the principal auctioneer to 60 days, but to No, I'm sorry. Well, then it would be just great if you all could let me know if you're planning to adopt the suggested changes or not. Now, Mr. Hines indicated he has some other questions, but
I thought I heard a commissioner say that we're in favor of leaving them like they are.
okay,
That we're
I'm
in
sorry. Then I
disagreement.
misunderstood. It would be real. That's why I'd ask for motions on some of these so that when I'm drafting comments,
Right.
I don't misunderstand anything you all state. So I apologize.
I was making a comment. I was not making a motion.
I'm sorry.
I would move that we not make the changes as suggested by Mr. Hines' letter here.
I'll second.
It's been moved, and I'm sorry, Julie, did I jump?
No, when you discussed it, he indicated he had something else he wanted to say. If you all would like to talk about that during the discussion period before you vote.
Sure. One last point I want to make is, Tennessee is a great state to do business, and it is my belief that when the law was passed in 2006, the intent was to not burden the online auctions, with the regulatory burdens behind the getting a license and the rules that would, come with that. And so, as a free market-oriented policy passed by the legislature, I think by adopting the rule today, less companies will be able to take advantage, of that rule in 2006. And so we go from a large class of online auctions who can obtain exemption today to a smaller class of online exemptions. And, it's my hope that, as we work with this issue, that we would continue to favor free market policies and not decide which companies will have regulatory burdens and which companies will not have those particular burdens. So anyway.
Response to that is I know you're looking at it through the eyes of your business, and I appreciate that, but we have to look at it through all online auctions, and we're seeing a barrage of real estate auctions being held online, and those have a little bit more serious consequence than the automobiles and insurance salvage that you have in your business. So we have to really kind of look at it from a broader base than through the narrow vision of your company.
It's been moved and second that we adopt the new rules as written.
That you not make any changes.
Not make any changes.
You're not making any changes, okay. You all would need to vote, I think.
We have a motion and a second.
All in favor say aye.
Aye.
Aye. Unanimously passes. Sorry.
The next person that has the last written comment that I have is from the Nashville Auction School. Ms. Hansen's also on the list to speak, so if she'd like to come up now and address her written comments as well as anything additional you'd like to say.
Good morning, I'm Ressa Hansen with Nashville Auction School, and I appreciate the opportunity to speak. Let me start by saying overwhelmingly Nashville Auction School is in support of the proposed rule changes. I do have some comments on 3 specific proposed new rules. The first being proposed new rule 0160-01-.26 escrow account requirements. Nashville Auction School supports this rule, but would like to clarify the importance and purpose of escrow and trust accounts. However, it's our opinion that the wording of this rule could tie more closely to the code that it represents. TCA 6219, 112, subparagraph B, subparagraph 4, which is the law under grounds for revocation and suspension of a license, states that the Commission may suspend, revoke, or refuse to renew any license issued under this chapter for failing to account for remitting within a reasonable time any monies belonging to others that come into the licensee's possession, the commingling of funds of others with the licensee's own, or failing to keep such funds of others in an escrow or trustee account. Below that, I have 3 bullet points. The first one is just simply a typographical error where I ask that the language, the term escrow or trust account, be changed to read escrow or trustee account, but in the proposed rule it does say trustee account, so we can disregard that one. The second point is the language all funds that belong, we request that be changed to any money belonging to others to more closely tie it to the code. And the third bullet point.
Let me stop. You said,
Okay.
So you want to change where it says all funds that belong after the word for.
Correct, and I actually have it rewritten with my suggested changes at the end of the suggested change.
Any money belonging to others.
Right, all funds basically to any money belonging to others.
What is the difference between all the money I owe you or any money that I owe you? If I owe you money and I've got it in my trust account, my escrow account, it's any of your money or all of your money.
And I do think that there could be a difference. I do think that there could be a difference. It may not be all the money I owe you, but I have some of the money that I owe you, which would be any money. And
But the rule says that all money
belonging to
taken
others.
from
What
the
if you don't have
proceeds
all
of an
of it?
auction should be
I think she's got a point.
deposited in an escrow account.
But actually, I'm supporting this rule. I just am asking for a language change to tie it to the law.
Too, but I don't
Okay.
see the difference.
It says all funds that belong to others, and what the law says is any funds belonging to others. Because, and the example that I can give you, Commissioner Phillips, is under a contract, it is not uncommon for an auctioneer to take prepaid advertising funds, for example, to spend on behalf of the client. Those funds are still generally considered to be the client's fund, and the auctioneer, as an agent for the seller, is acting as a fiduciary of those funds. That doesn't mean that they can't distribute those funds appropriately to the terms of the contract. It just means that they would be in possession of those funds for a period of time. And certainly there have been instances that I'm aware of where auctioneers misappropriated advertising funds in the past belonging to others that were not in the best interest of their sellers. So, it just opens up the door. All I'm asking is that it tie more closely to the language of the code. And going forward, basically the biggest point that we would like to make is the last paragraph of the first page, as a result, where the language of the proposed rule uses the term as a result of an auction sale. And again, back to the example that I gave you, we would request that this commission change that language to state as a result of an auction contract, because the sale is an action that takes place because of the contract, and that monies may change hands at the signing of the contract prior to a sale. And if the sale never comes to fore, that doesn't mean that the auctioneer is not responsible for those funds. So
I understand mostly what you're saying, but I would like for Julie to comment on this and clear my brain up. But if I book an auction to sell her house and I tell you that you've got to give me $2,000 up front to spend on advertising, I don't see where that money would need to be into the escrow account. That's
I don't either.
That doesn't make any sense to me, that you're going to receive money to spend to promote your sale. Do you agree with that? Am I wrong?
my question is, whose money is
You gave
it?
me that money to
Oh, that-
spend.
Is whose money is it? And
Well,
it goes
in-
back to that code, is
in-
all funds belonging to others that
it's-
come
Well, it
into the
depends on what the
licensee's
contract,
possession.
how the
Right
contract
now-
reads.
Correct.
Right now, it says all funds, but the law right now, the law says all funds, but the rule says any. Is that what you're saying?
That's
Or
correct.
vice
And
versa?
I read the law, the law says any money belonging to others. And my understanding when I read this rule is that it is designed to clarify that law as far as what falls under the category of any money and what money belongs to others. So that if I, as a seller, contract with Commissioner Phillips to conduct an auction for me, and in the course of that hand him a dollar bill to go to the Coke machine and get me a Coke, is that any money that belongs to others? And that's what the way I understand this rule to clarify that is what money belongs to others. However, I do believe firmly that when I enter into a contract with an auctioneer as a seller and I entrust my funds to that auctioneer to spend as my agent, they have a fiduciary responsibility to properly account for those funds. And whether I give them to them at the time of the contract or at the time of the sale, when those transactions are transpired and the hammer drops and the auctioneer cashier collects the funds for the transaction, I am still giving those funds to that auctioneer to secure and to spend in accordance with the contract and to keep in trust. And I think that that's the spirit of the law. I think that's what the law says, and I think that that's the spirit that this rule intends to clarify is my interpretation and my reading of it, and that's what I'm asking this commission to review. And so my suggested changes would change it. It's at the top of page 2 to read, all licensed auction firms and galleries shall maintain an escrow or trust account for any money belonging to others that come into the possession of the firm or the gallery as a result of an auction contract, which in effect says the same thing. It just ties it more closely to the code, and it specifies that it doesn't leave that open end of being held. What do funds being held mean? And so, that was our question, is that are all funds belonging to others to be held in trust? Or if I go to Commissioner Phillips' auction and we enter into a contract and he pays me the night of the sale and pays me cash, does he have to account for those funds in an escrow or trust account? Am I as a consumer protected or not? And I think that the language of the current language of being held by the firm or gallery as it currently reads opens that up.
I would like for Julie to comment, but I would like to make one comment. If you hire Commissioner Phillips Auction Company to do your sale, I assure you they will not pay you in check and they will not pay you the day of the sale. They'll put the money in the escrow account and give you a check tomorrow.
And I agree.
Well, and I'm kind of like Howard too. I get money up front to spend for advertising or promoting a sale or cleaning it up or whatever. I'm going to do what the contract says and use that money to do that.
Where you all had originally directed that this language for this rule be pulled from was actually not directly from 6219-112. It was pulled from the language that exists within 6219-117, which is your reciprocity statute. Those are your requirements for non-resident auctioneers. Specifically, subsection C of that statute states every non-resident auctioneer shall obtain a firm license as provided in section 6219-111 and shall maintain an escrow account for all funds belonging to others that come into the non-resident auctioneer's possession as a result of an auction sale in this state. And when we first, these rules have been through a plethora of changes over the months. But when we first began these discussions, to the best of my recollection, the direct issue that one of the commissioners brought up was we have this specific statutory requirement that says this for non-residents, and we don't have something similar for our resident auctioneers. All we have is the disciplinary statute, which Ms. Hanson did address, and as she pointed out, is worded a little bit differently. When we started drafting these, I believe it was the Commission's wish to keep this rule as close as possible to the requirement that's in the statute for non-residents. And that's, what I can speak to as far as the language, because I draft these at you all's direction, and that, to the best of my memory, is why this was drafted in this particular
In your
manner.
opinion, would we be better off to say any or all?
I don't know. I don't personally see the distinction there, but this has all come on me today. So, as far as me giving you something, this is very off the cuff. It's off the cuff. Like I said, in any given situation, I think the facts would determine. I think the facts can be wildly different. She gave you a great example of somebody that gave you money for advertising. That could be totally different than someone where there has been a sale and you're holding money that came in from a bid. That's two totally different things on two opposite ends of the sale that took place. And so, as far as all or any, I'm no expert on that.
My comment is you could turn that around and say, I've accounted for some of the funds. So that could be any, but I haven't accounted for all the funds. So what we're looking for, we're looking for is to make sure that all the funds are accounted for, not just some of them.
Correct.
And so that would be my argument against changing all to any. As far as the result of an auction sale or an auction contract, I don't know how many. I know there's a lot of auction barns that do it on a handshake. I don't know there's a lot of contracts issued in those cases, and I don't know whether an auction contract would cover that. I know you're supposed to have a contract, but I know a lot of people skip over that step, and so I think that's why they were going trying to say from an auction sale of any kind.
Perhaps a sale or contract.
Could be. But I think your points are well made, but I don't know. I think you can argue about Bill Clinton and says, what does is mean? But I don't think we want to dissect the wording that badly, but
I'm afraid that as it is written, it opens up the door for those very auction houses and businesses, unlike Commissioner Phillips' business, where things are done right. The ones that are causing problems, it opens up the door to make it easier for them to comply with the law and still create problems and comply with the rules.
And I think she's correct. There is a potential disciplinary action that I do want to point out, that someone can be disciplined for failing prior to the sale at public auction to enter into a written contract. So actually our law, although I've realized that doesn't mean that's how it's done, our laws do contemplate that is supposed to be done in all cases.
And that's the law. And personally, I appreciate your comment, but I don't see enough difference in the wording to change it.
The only one that I do
I am not a lawyer.
The only thing I do think does make some sense to consider is coming into the possession of the firm or gallery, because if you're saying, well, I didn't hold anything, but I had it, I think that that is anything that would broaden that definition, I think we ought to consider, and I would consider taking that into consideration, the coming into possession of the auction to the firm or gallery, because no matter how it came, if I'm not holding it, you say, well, I got rid of it as soon as I got it. I think that would be better if we could maybe consider doing that.
Livestock or
I do.
You all want to make you seem pretty close to making a determination on this one, and Ms. Hanson's brought up a variety of things for you to consider. Would you all rather take this and, finish this one up, or would you like to think on it and move on? It's up to you. It just seemed like you were pretty close to making a.
I would make a motion that we do change the wording from "but which are held by" to "coming into the possession of the firm or gallery." And at the end of that sentence, if we say an auction contract or sale, is more broad than saying either sale or contract, and I would make that recommendation. Leave the word all as all and not change it to any. I think any can be misleading.
Sale in there, would that mean that we're condoning the process of having an auction without a contract?
Man, I don't know.
That's a good point. Julie?
I'm sorry. What I
We put in sale or contract, are we saying we recognize the fact that they may have a sale without a contract?
think that. I think clearly the meaning war is either or.
You have to have a contract.
Having a
Or should-
contract to me should go without saying. So maybe we'll just leave it sale. Because
that's
having a
my
contract
idea.
ought to go without saying.
I think when you put an or in, it appears to create the impression that it's
Right.
one or the other.
Right.
And,
We'll just
but
leave that one alone.
Okay. I guess my wording on that would be all licensed auction firms and galleries shall maintain an escrow or trustee account for all funds that belong to others coming into the possession of the firm or gallery as a result of an auction sale. Changing "but which are held by" to "coming into the possession of the of."
And your reasoning for that was that you all don't think that held covers enough.
Held means that.
I just want to be clear for in our
Right.
responses that we have.
I think it's a broader definition, in my opinion.
what you've changed it to. Okay, I understand.
Licensed
Thank
firms
you.
and galleries shall maintain an escrow or trust account for others. Well, now,
Into the possession.
how much plainer can it be belonging to others? I don't see the difference in coming in possession
Well,
or
to-
belonging to others.
No, he's not changing belonging
I'm
to
not
others.
changing that.
He's changing "but which are held by" to "coming into the possession of."
Sorry,
It's okay. It's a little confusing taking out the middle part of it. As I
Okay.
understand it, Commissioner Morris is saying that it would read, all licensed auction firms and galleries shall maintain an escrow or trustee account for all funds that belong to others coming into the possession of the firm or gallery as a result of an auction sale.
Second.
did you make that as a motion?
I did.
Okay. We have a motion and a second. All in favor, say aye. Aye.
Moving on to livestock auction sales. Under Rule 0160-01-.27, livestock auction sales, subparagraph 3, this is a proposed new rule, states if the operator of a livestock auction sale that is registered with and regulated by the Packers and Stockyards Administration sells any item other than livestock at a regulated livestock auction, and the proceeds are deposited into the shipper's proceeds account, then neither a Tennessee auction firm nor a Tennessee auction gallery is required. Any such auction must still be conducted by a Tennessee licensed auctioneer. It's our opinion that the language of this paragraph is both confusing and in direct conflict with the requirements of the Packers and Stockyards Act under Section 201, subparagraph 42, and others. First, the language refers to the shipper's proceeds account. However, the Packers and Stockyards Act uses the specific term custodial account for shipper's proceeds, and in short, it uses the term custodial account. So on their brochures and all of their publications, they use the term custodial account. So when referencing this trust account, I have an excerpt from paragraph C of section 20142 regarding deposits into the custodial account that clearly state that the market agency shall deposit in its custodial account before the close of the next business day, number one, the proceeds from the sale of livestock that have been collected, and number two, the amount equal to the proceeds receivable from the sale of livestock. I've also given each of you a copy of their brochure handed out by the United States Department of Agriculture with regard to instructions on for Market's Guide to Custodial Accounts, and highlighted the paragraph, proceeds from the sale of items other than livestock. And it clearly states a market should deposit proceeds from sale of non-livestock items into its general account unless these items are sold with livestock and the buyer issues one check in payment for both. In that instance, the market should deposit the proceeds into the custodial account and transfer the non-livestock amounts into the general account. Then, even if one seller consigned both livestock and non-livestock items for sale, the market must draw payment due the consignor for livestock from the custodial account and payment due from the non-livestock items from the general account. So for a livestock market, it is our opinion that the sale of personal property assets at a livestock sale opens up, this rule contradicts the Packers and Stockyards rules for that market, and then opens up those sales proceeds being deposited into a general operating account and not into an escrow or regulated account. And by not having a firm or gallery license, they're not required to have an escrow account, so it deregulates the sale of personal property at auction during a livestock sale. We think that that is contradictory to the mission of this commission and in conflict with Packers and Stockyards administration. So we respectfully request that the Tennessee Auctioneer Commission strike paragraph 3 from new rule 0160-01-.27.
Where's Marvin Alexander when we need him?
I'm thinking the same thing.
We got a livestock auctioneer here, Mr. Collier. That's what he does for a living. You were talking about selling saddles and
I'm saying
hammers and horseshoes.
If I as a seller consign horses and saddles, the Packers and Stockyards administration does regulate the sale and the accountability for the funds being held in trust on the transactions related to the horse or the livestock, but they do not regulate and will not regulate or secure the funds for the sale of the personal property assets. Historically, at some point, and we don't remember exactly when it was, but it was probably a good 15, 20 years ago, someone, and we don't know if it was the Auction Commission or the Packers and Stockyards Administration, we saw it big in Shelbyville where they went into these horse barns and made them get gallery licenses for this very reason. Now, over the years, that's kind of just sort of, gone different ways, and some do and some don't. And there is confusion, and there's confusion with small livestock barns that are selling both, and there are confusions for consigners. But what this rule does is if I as a consigner consign both, I'm protected on the sale of the livestock by the Packers and Stockyards Administration, but I'm not protected by anybody anymore on the sale of my personal property because the Auction Commission has exempted licensure. And you've made that a requirement of that exemption for the market owner to deposit those funds in an account where they have clear instructions not to do that. Their clear instructions contradict this rule. And again, back to what Mr. Morris was saying earlier, it's an expanded exemption that maybe this commission might not want to give, and we're asking that you remove that whole paragraph.
I'm sure he was part of it whenever we started it.
I know nothing about it.
stockyard, and the Packers Association has always been clear as mud to me, and I do understand what you're saying, that if you're going to sell other than livestock, saddles and cars and trucks and tractors, then you should have an escrow account. Is that what you're saying?
So, yes, and you should have a license.
This rule
And a
right here
license.
exempts it from that. If you read the rule, it says if anything is sold other than livestock, and they use their, and this is this paragraph 3 that she's talking about.
The rest of the rule is fine. It's
Yeah.
just
Okay,
that
I
one
got it.
paragraph gives an
So-
exemption.
So your suggestion is that we not adopt paragraph 3.
My request is that you not adopt paragraph 3, that you strike it.
I didn't understand the rule at the time myself.
And we don't have a lot of guidance in our statute. It just says, the exemption that we're working from is that you're exempted from the provisions of this chapter for any livestock auction sale regulated by the United States Department of Agriculture, Packers and Stockyards Administration if the sale uses A, the shipper's proceeds account required by federal regulations, and B, a Tennessee licensed auctioneer. And that's really
I think
only-
Marvin's thinking back when he was on the commission was that if they're already covered under the Packers law, then we should make them double up. I think that's what his thinking was.
Right.
But evidently they're not covered.
But that's
But
not.
they're not covered
they're
under
not
personal
covered.
property.
I
They're-
think he thought that they were, and he thought that that money went into that custodial account. But you're saying it does not go into their
Cannot.
custodial
It
account.
cannot. It must not. And
Right.
it must not. And it must not be
That's what
paid
they
out of
say
that.
right here.
Right. That's
But
from the USDA.
But I know that's what it, because I remember sitting here listening to him back when he was talking about this rule, and he thought, well, we're double making them get double license to sell the same thing, and we're not.
For a livestock market that just simply sells cattle and horses, then they're exempted already, and they are covered under the Packers and Stockyards Administration. What this runs the risk of doing is opening up a livestock market that sells one registered cow and 600 lots of personal property without a license.
Ms. Ressa, it's hard for me to say that you're correct, but on this instance,
Every once in a while, I hit it.
I think I'm
okay.
going to have to agree with you.
Thank you, sir.
Ronnie, do you have any comment on that?
I agree with what she's saying. I mean, the money all money should be in an escrow, and I agree with what she wants to do. Should be changed or left alone.
What's she saying, strike?
Well, strike.
I think what she's asking is to strike paragraph 3 and then renumber 4 and 5 as the new
Correct.
3 and 4 is in
Act like
short
it
what
was,
she's.
right.
I'll make a motion to accept what Russell is recommending.
Second.
I'll second it.
Been moved in second that we strike paragraph 3 and leave the rest as is. All in favor say aye. Aye.
And I think you all made I think you all made your intent behind why you did that very clear. So I think you're good to go ahead and.
We're okay with that?
Yes, I understood it, and with the help of the transcript, I'll be good to go.
And finally, my third comment is housekeeping and grammar only. Just as a matter of housekeeping regarding Rule 0160-01-.28 online auctions, with regard to this proposed rule, there's our language usage inconsistencies. In the first sentence, if the time for an online-only auction with a fixed bidding time is extended beyond the online auction's fixed ending time, then the auction and the person conducting the auction are not included within the exemption. The term online-only auction describes a type of auction where online only becomes an adjective to describe a noun, auction. According to the Chicago Manual of Style, the compound adjective is hyphenated when it precedes the noun and is not when it follows the noun. Therefore, we request online-only auction be corrected to the hyphenated form online-only auction, and similarly request hyphenation for fixed bidding and fixed ending to be corrected to fixed bidding and fixed ending with a hyphen. Additionally, the online-only auction is subsequently referred to as the online auction. Since this rule is specific to online-only auctions, we believe the use of the term online-only auction is clearer and would serve to avoid any confusion about the type of auction that this rule is addressing, whether it is addressing an online-only auction or just an online auction. Further, we are of the opinion that the auction's fixed ending time represents both an incorrect usage of the apostrophe S and requires fixed ending to also be hyphenated. So we believe that just the corrected grammatical sentence would state beyond the fixed ending time of the auction, because we don't believe an auction can be possessive. But for the purposes of housekeeping, we request the corrections be made to the proposed rule 0160-01.28 to read, if the time for an online-only auction with a fixed bidding time is extended beyond the fixed ending time of the online-only auction, then the auction and the person conducting the auction are not included within this exemption. It's just grammar.
Personally, I've never been to the Chicago Manual of Style, so I. What do y'all think about it?
My English teacher, it's just grammar.
Grammar, so.
Didn't work.
Yeah.
Just, there's one thing that you did say up here. Additionally, the online-only auction is subsequently referred to as the online auction. Would that also continue to the bottom to state at the very end shall govern the online-only auction?
Fixed ending time. I did include that in there.
I'm sorry, I saw the ellipsis
fixed ending
here,
time
and I thought it cut off.
of the online-only auction. No, it's just in that one.
Just up in the
In the
first
second
line. The first.
Well, it's in the first line, and then again in the second line is where I replaced online auction with online-only auction.
Well, I guess I'm talking about in the notice of rulemaking hearing. At the end, it says, "And the rules of the Tennessee Auctioneer Commission shall govern the online auction." Are you
okay, so I just
suggesting
didn't
that
go
it be
for
changed there
yes,
too?
all the way through.
I just wanted
Yeah,
to be sure because it
just
looked like you were.
just for consistency.
I just wanted them to have a. She's also, although at the end of her italicized language, it ends with an ellipsis after the word exemption. That would also include, if you look to the language in the notice of rulemaking hearing where it says online auction, the last two words, that would be including, she would want to include online only with a hyphen in there as well.
I just didn't read far enough.
It's okay. I just wanted to be sure that when they were considering it, we had all of your comments in there. So. At the end on your notice of rulemaking hearing, where it says online auction, she's just continuing what she's requested in the first part to say online only, wherever it says online. Would that be correct?
That would be correct, to change online hyphen only.
If we
where
read
it says online.
the entire thing, and please correct me at any point if
Yes,
I'm wrong.
please.
If the time for an online-only auction with a fixed bidding time is extended beyond the fixed ending time of the online-only auction, then the auction and the person conducting the auction are not included within the exemption specified at TCA Section 6219-103, and the statutes and rules of the Tennessee Auctioneer Commission shall govern the online-only auction. Would be how.
Okay, so you insert hyphen only.
At the end
At the
as
end.
well. And the rest of what she has here is already typed out fully.
Counsel, are you comfortable with
I'm
that?
not familiar with the Chicago Manual either. Obviously, neither are all the people that reviewed it after we drafted this. I don't see any change at all to the effect of this rule based on what she's saying. I don't see that. I mean, again, this is all, I got these comments right before the hearing, and I'm not a language expert either, but I don't, in my opinion, from looking at this does not change the substance of the rule. But you all can take a minute and look at it if you'd like to, if you have concerns. It does not appear to change it, in my
I think
opinion.
it's fine. I would move to radical changes.
I'll say.
Been moved in second that we go with the Chicago Manual of Style. All in favor, say aye.
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 Thank you very much.
Time to review this so carefully, and we appreciate you and Wendell's effort on this
We have 3 more individuals on the list that are signed up to make comments, and I was just going to call those in order. The first is Mr. Robert Treadway.
I would yield my comments to Ms. Rye.
Before we do the next one, the commission would like to take a 10-minute break.
That's fine.
Julie, Kimberly, I have scribbled all over your minutes page. I didn't realize that's what it was.
The only thing that matters is the
Yeah, all she's
signature
got to do is
page.
just put a new front page on it. I didn't pay attention to it.
To make the written comments that were submitted an exhibit to this record, please. And I have a copy of all 4 of them. They can be collectively labeled if that's possible. Right before we broke, I called Mr. Treadway's name, and he indicated he wanted to yield his time to Miss Karen Rye. Is that correct? And Miss Rye is the next person on the list to speak. So, Miss Rye, if you'll please come forward.
Hi, I'm Karen Rye with the National Auto Auction Association. Thank you for allowing us time to provide comment this morning. Most of mine are really just for clarification and consistency, or to educate me to make sure I'm understanding correctly. My first comment is with respect to Rule 0160-01.01, and it's the addition of the new paragraph 2. And it's the requirement that licensed auctioneers only accept offers for hire to call bids at auctions that hold a gallery license or are owned and operated by a licensed auctioneer holding a valid firm license. I just wanted to confirm that it's not intended to exclude non-auctioneer owned firms that have a firm license.
Well, the reason why it includes an auction house, auction barn, or auction gallery that is owned or operated by a licensed auctioneer holding a valid firm license, that's pulled directly from the statute 6219-125A, which is the gallery license requirement. The last sentence of that section states, if the auction house, auction barn, or auction gallery is owned and operated by a licensed auctioneer holding a valid firm license, no further license shall be required. So the way that statute is worded, the gallery license is only not required if the firm is owned and operated by a licensed auctioneer. So that would be the only reason why the gallery license wouldn't be required per that statute.
So just so I can understand, what is the non-auctioneer owned firm license? Does that coexist with a gallery license?
That's also a firm license, but like I said, this statute that they're working off of as their authority only states that a gallery license would not be required if the firm is owned and operated. So to expand that beyond their statute would seem to be a conflict with this provision 6219-125A,
okay,
which only states that no further license shall be required in the instance where the auction house, auction barn, or auction gallery is owned and operated by a licensed auctioneer holding a valid firm license. Well, I'm sorry.
I think you're talking about an auctioneer-owned firm. She's talking about a non-auctioneer-owned firm.
Okay.
Right?
Right, and unless I am interpreting this incorrectly, when I read this, I'm reading it that a licensed Tennessee auctioneer can call bids for an auctioneer-owned firm that has a firm license or a gallery licensed entity, but they could not call bids for a non-auctioneer-owned firm.
Bids for anybody.
Or out in the middle of the street.
I think that the underlying purpose of this rule is stating that a no licensed auctioneer can call firms for an unlicensed gallery, basically an auction house or something that is not properly licensed. It's putting some of the responsibility on that auctioneer of making sure that the gallery is properly licensed. And a gallery, the gallery itself, this is not having to do with the auctioneer. Mm-hmm. The gallery has to have, the auction house, barn, or gallery has to have a gallery license unless that specific gallery, this is again not relating to the person who would be coming to call.
Right. If
the gallery is owned and operated by a licensed auctioneer holding a valid firm license. So the gallery that this auctioneer would be coming to call for would either need to have a gallery license, or the gallery would need to be owned and operated by a licensed auctioneer holding a valid firm license.
Okay.
Could I ask you a question, please?
Mm-hmm.
What, I got myself, as usual, a little bit confused. What exactly is your business, and why are, and I'm curious, why are you asking this question? Maybe if I know what you're doing and why you're asking the question, my brain might work better.
I'm with the National Auto Auction Association, and we have approximately 8 auctions in the state of Tennessee who may be holding different classes of licenses. So it's really just to understand the rule changes in case we get questions from the membership. So that I can make sure I
primarily
understand.
you're talking about auto auctions, right?
Yes. Solely for dealer-only auctions.
And auto auctions have a tendency, or they use auctioneers from out of state and in state, and that is that your concern about the license?
Well, and I don't know that I necessarily had a specific concern with this paragraph. It was really just to understand, because I know that so many of the rules focused on non-auctioneer owned firms, and I felt like they were not brought into the scope of this specific rule. But now that I understand where you pulled the language from, you're kind of limited to the language that you can put here. So that helps me somewhat.
The statute that it was directly pulled from is 6219-125A.
125.
So that's what you could point your members to if there
All right.
was a question. Because originally, as written, this rule that the commission wanted to state that a licensed auctioneer could not call bids at a gallery that didn't have a license. But it was actually brought to our attention, I believe, from the AG's office, that this one provision at the end of this subsection, if the gallery was owned and operated by a licensed auctioneer with a valid firm license, then that's the one instance where a gallery license isn't required. That's the only situation where the statute kind of goes outside and says you don't have to have galleries only if this is the case. And that's the rule is basically restating what that statute states right there.
Okay.
You good?
I'm good with that. My other comment has to do with Rule 160-01.26, the escrow account requirement. And I now understand through conversation here today that language was pulled from the reciprocity portion and not the disciplinary statute portion. But there is an exception specifically in 6219-112-4, B4, where it says, provided, however, that nothing in this section shall be construed to require an auto auction as defined in section 5517-102-2A to maintain or use an escrow account when the auction does not accept and deposit funds of others.
Wait a minute, where are you reading that?
Out of the existing rules here.
She's reading that
On
from
page
the
10.
statutes. Specifically, she's reading it from 6219-112, which is your disciplinary statute, and she's reading particularly from subsection B4. That's correct, right?
Yes,
I was
yes.
reading along with you.
And my comment is that just for clarity and consistency, especially since this particular section I think has come up 3 times this morning, it shows we can all interpret it a little bit differently. I would like to see that language, starting with the provided however, about the auto auctions to be carried over into the rules so that there's not any inconsistency or question.
Have the copy of the statute?
I have the copy, but I did not find it.
It's on page 10, Howard.
Thank you so much.
6219-112, and it's specifically B4.
I think kindergarten is ready.
Now, what was your concern again?
I would like to see the specific language about the exception of auto auctions as defined in section 5517-102. I'd like to see that language carried through from the statute to the rule, just for clarity and consistency.
Our adopted rule 126 is what she's saying.
All auctions not accept deposit of the funds of others?
I mean, I only have the knowledge of what she's stating that the rules state. I mean, that the statute states.
I mean, I'm sure there
I
was a
mean,
reason
as
that
she-
exemption was put in there.
Nothing in this section that we can require an auto auction.
I mean, if they don't accept the funds of others, I don't see any problem with it, but I'm sure if they do accept the funds of others, they do have escrow accounts, I'm sure.
You're talking about auto auctions?
Yeah.
Yeah.
Not
Yes.
accepting funds of others?
I specifically am just requesting that the language from the statute be carried over into the rule. I wasn't, the addition of the language in the statute was pre-me, so I don't know what those arguments were, but I just wanted that to carry through into the rules so that everything is clear and consistent. My fear is that if there is someone relying on some kind of exemption and that not be carried through to the rule, that they will think that they have lost the ability to not accept funds for others and not have to have the escrow account.
You are suggesting that we say that auto auctions have an escrow account. Is that what you're saying?
I am suggesting that you carry over the language from the statute into the rule so that it says, provided, however, that nothing in this rule shall be construed to require an auto auction as defined in section 5517-102-2A to maintain or use an escrow account when the auction does not accept and deposit funds of others.
Okay. Do you want auto auctions to have escrow accounts?
I'm sorry?
Do you want auto auctions to have escrow accounts? Or not have escrow accounts?
Well, I think when they don't accept the funds of others, that they don't have to. And since I'm here for
Okay,
the National
okay, let
Auto
me stop
Auction
you right there. Now,
Association-
I've been to auto auctions in several states, and I've bought cars in several states, and every time I bought a car, I had to go up and pay for it.
Mhm.
So you got my funds. Why should you not deposit my funds in an escrow account?
I think what she's just saying is just in those cases, like where the statute says when the auction does not accept and deposit funds of others. I think,
And I like you, you're my friend, but I'm not understanding.
When is that ever the case is what Howard is asking.
Well, it must be because it's in here.
But I-
That's confusing to me too.
I think what-
Can I,
Yeah.
Robin?
Say something? It's a pass-through account.
can you identify yourself for the court reporter, please?
Robin Treadway, and I'm with Dealers Auto Auctions here in Tennessee. It's more of a pass-through account. The check is, the funds are paid, you pay for the car, and we immediately write a check to the seller.
Still, that counts as needing to go into escrow.
You know, and
That's
I think
the-
excuse me, go ahead, I'm sorry.
By being a pass-through, I think you still have to account for those funds.
Our only problem, gentlemen, is we can't, a statute and a rule, if they conflict, a statute governs, and our rule does not, as written, conflict with that. It's just it doesn't specifically.
I
and so
understand.
you understand that. I know, but
I understand it perfectly.
I think
Okay.
we're all missing the part right here where it says at the bottom of this that I think clarifies it all as clear as it can get is the last sentence. It says does not accept and deposit the funds of others. So I got no problem with it because that's what this says. If you do not accept, I don't know when it would happen, Howard, but it's in the law. So apparently it's happened sometime. So I don't know when it would happen.
But a pass-through doesn't qualify as not accepting or depositing funds of others.
Yeah, but I don't even know that I don't even know that what Robin's talking about is what this is means.
Well,
I would.
Well, what I'm thinking and what I'm talking about is we own a public auto auction. And public auto auction is a little different from a dealer's auction, but it's the same token. Somebody buys a car, they pay for that car. And you, not you, but the auto auctions have got to deposit that check somewhere. The way we do, we deposit into an escrow account. And Nashville Auto Auction, as big as they are, takes in caboodles of bushel baskets of money and checks every sale. And they have to make deposits, so why wouldn't they have an escrow account?
I don't know when that would never be the case.
And I'm not here trying to change anything. I just wanted to request that the language flow through from the statute to the rule.
I understand what you're
What
saying,
is
but my point is, I would rather leave it like it alone, and if anybody wanted to challenge it, let them challenge it.
Okay.
Well, what is, I agree, but what is the definition of an auto auction in 55-17-102?
55-17-102 is part of the Motor Vehicle
Right.
Commission statutes. Let me see. 55-17-102 2A. Automobile auction means A, any person offering motor vehicles for sale to the highest bidder where buyers are licensed motor vehicle dealers or their duly authorized agents. So that is what 2A is, and that's what it right. So that's dealers auctions.
Right.
I would recommendation that we leave our language alone, and if anybody wanted to challenge that rule as opposed to the statute, then let them do it in court.
Well, I mean, I don't think there's really anything in the rule that conflicts with the statute because it says that.
She's looking for clarification.
Yeah, I don't think there's anything that conflicts with it because it says, over here it says, if they don't handle the money of others. So I think it's in good shape.
Okay. I'm good with that.
Just have to rely on the statute, not the rule.
Okay, coming away from here, what did you learn, or what did
I learn?
Or are you still confused?
I think he's asking, do you have anything else, right?
Yes.
Is that's all he's asking.
No.
He's not giving you a pop quiz.
are we happy?
He's asking you if you had any other comments.
I am happy and I have no other comments.
There you go.
So everything's good.
Thank you for your comments.
Thank you.
Did you all say by motion that you didn't want to make any changes?
I'll
sorry.
make the motion that we not make any changes
That you don't
pursuant to
believe that
that
it's in
commentary.
conflict? Is it that you didn't think it was in conflict with
Well,
it,
there's
or-
no conflict, and even though it doesn't carry it over from the statute to the rule, the statute's still there and it can be relied upon.
Okay, thank you very much. I just appreciate a motion. It's easier for me when drafting the responses.
Second.
Been moved and second. All in favor say aye. Aye.
Right. The next person, we have Mr. Treadway, Ms. Rye, Mr. Hines, Ms. Hanson. The next person is, it looks like Patty Baldini. Am I saying that right? Baldini. I'm
Baldini.
sorry. Come up, Ms. Baldini.
We all know Patty.
Hello. Good morning, Commissioners. I am Patty Baldini here in Nashville, Tennessee. I have a comment, simply this. In regard to the new rule 0160-01-.28 online auctions, I support this, and I thank you for your efforts in creating this new rule.
Thank you.
Do you need any response to that, Ms. Baldini? Okay. all
Thank
right.
you, Patty.
Thank you for your comments.
The last person that we have on the list is Mr. Will McLemore.
Good morning, Commissioners. I'm Will McLemore, and I'm an auctioneer licensed in Tennessee. And I wanted to make certain that you are aware of a consequence of a rule that's been proposed, which is 0160-01-28 online auctions. If you pass the rule as you have outlined it, it will change a business practice that has allowed me to legitimately sell titled vehicles for the public to the public without having any license other than the auctioneer's license and firm license that I have. If this rule goes through, I will no longer have the ability to do that, and I want to make sure that you are aware. And the only reason I've been able to do it in the first place is because I have sold vehicles exclusively on an internet-only basis for several years, because the motor vehicle law looks to the auction law to explain what's subject to its regulation and what's not. And with the exemption built into the auction law, it has not regulated the sale of vehicles on the internet. And so I want to make sure that you are aware of the consequence of approving the rule as proposed.
Well, there is a way that you can still sell automobiles. You can go get a public automobile auction license, and you can go.
I'll be glad to do that if I'm required to.
Thank you.
Did you have any requested changes, or have you already listened to the comments? I just want to make sure that you get an adequate response for what you're seeking to come.
No, I simply wanted to make sure all the commissioners were aware.
And Will, would you expound on that? Are you're saying that you can sell an unlimited number of vehicles online only because of that there's not an exemption under the law? Or
if you go back and look carefully at the motor vehicle statutes, they refer back to the auction statutes to determine the way that auctions of motor vehicles are to be regulated. And so if you go and you do that and you read through the exemption, then you can assume correctly that sale of vehicles online are not subject to either the motor vehicle law or the auction law because of the exemption as written.
saying that by saying an online auction has to have a fixed ending in order to be considered under the exemption, that disqualifies your business model?
Well, it would for me. It's essentially saying it's okay for eBay, which does not have a variable ending time or an extended bidding time, to continue to sell vehicles for the public, despite the fact that they don't hold a license or aren't regulated. But it's not okay for me, that where I am licensed and am subject to regulatory burden, to do the exact same thing. It's not, to me, it's not fair, doesn't appear to be fair. It's not the intent of the commission. I believe with the rule, I understand the intent of the commission and I support it, to bring those who are out conducting auctions without a license of any sort under the regulatory burden that every other licensed auctioneer shares. But it is the way that the laws in Tennessee are assembled is not necessarily the way that you would start if you had to write them from scratch from the beginning today. They are what they are. And due to an accident of history and the way that the laws are put together, the motor vehicle law refers to the auction law. This exemption exists and allows me to sell vehicles for the public, to the public. And I've been doing a good job of doing that for several years. And if the law is passed as written, it will close that loophole, as it were, and cause me to pursue the automobile auctioneer's license that I have not had to get so far. And it will bring me under regulatory burdens that I have not had to carry so far.
Well, I'm not familiar with what you're saying enough to argue about it, but I thought that the Tennessee law said that you could sell 5 cars at an estate if you didn't have an automobile auction license, period.
Right? That it does say that.
Where's the law that you said allows you to sell the cars now?
It's the exemption. It's a combination of the way the motor vehicle statute refers back to the auction statutes for determination of what's subject to regulation of auctions in general, and then the exemption as written into the law now, which says that timed sales are not auctions. That allows for those who conduct timed sales to sell at auction, essentially.
Have it in writing where we could see it.
Well, it isn't.
Yeah, it's in the law. It's
it's
in your book there. It's
Which one? Which one is?
Well, the
under
exemption.
exemptions.
The exemption is as written is. I think it's still 62-19-102. I believe is where it is. It's in the.
103 are the
Is it-
exemptions. Are you referring to
It's
their
103,
exemption?
the exemption.
Their exemption is any fixed price or timed listings that allow bidding on an internet website but do not constitute a simulcast of a live auction. Is that what you're referring to?
That's right.
I'm still fuzzy, Will, as to how this affects that.
The exemption, the motor vehicle statute is really the one that Ronnie, you're probably asking about, is what portion of the motor vehicle law is it that refers back to the auction law for the regulation. And I was looking at that before I got called up here, and I have not been able to find the specific chapter and verse there.
That's what I was wanting to see.
I had done it in the past, and I don't know what it is. I apologize for that. Should be better prepared, like my friend Ressa was. Anyway, it's in the motor vehicle statute, and it refers back to the auction law.
What does it say?
It essentially says to see the auction law for regulation of sale of automobiles or titled vehicles at auction.
How does this language affect that?
It essentially, if you were to take the statute in the motor vehicle sales law, and I think it's in 55 is where that is in the in Tennessee Code. And if you look back and it says, look back at the auction law for regulation of the sale of motor vehicles at auction, and you go back in and look at that, the first thing you're going to read in the auction law is the exemptions. And you get to that and you see what's exempt from it, and you say, okay, well, we'll do timed auctions of motor vehicles, and they're not exempt to regulation by either the motor vehicle law or the auction law because they are specifically exempted.
Well,
what it is, we're changing.
Well, I think you all
The
have always
definition
read
of a
this
timed
exemption. You all, the way you would describe this to me is you have always read this exemption as the way you are writing this rule. This is how you've always understood it. You've always understood it as this statutory exemption was not meant to extend, to apply to extended auctions. I think what he's saying is how maybe someone else, maybe it's the Motor Vehicle Commission, I don't know, how they've read this exemption is different than how you all have understood this
The same exemption that allows him to sell cars, the same exemption that allows Will to sell cars is the same exemption that allows someone without a real estate license to go online and sell real
They
estate.
still can. I mean, even after this rule is written.
No, not after this. They won't be able to.
Why not?
Not if it because it's got to be a timed event.
well, he can say it
It
ends at 5
still
o'clock.
is. Yeah, just,
Right.
Sure.
It's got to have a
5
hard
o'clock.
close. It can't have a soft close. You're
Right.
saying that difference is what's going to affect your business.
Right.
Well, my business model is such that it would be better for me to take the regulatory burden than it would be for me to close my auctions at a set moment in time. But that raises the question is, how are the consumers necessarily protected better in an auction that has a set closing time versus an auction with an extended bidding time?
We're not saying that is the case. We're saying we have a problem with online auctions only by unlicensed auctioneers.
I hold a license. That was one
Oh,
of
I
the first things I
understand that,
said.
but it's not aimed at you, it's aimed
Yeah,
at.
it's a sad
the-
situation that
the-
someone who's licensed is getting
I
penalized.
understand that.
You know.
I understand.
I mean,
Well, I don't think your licenses are getting penalized. Personally, I don't know for a fact that what you've been doing all along is legal. Because it says that, and we've been over this 100 times about online auctions, a beginning time and an ending time. And if it goes beyond if you extend it, what does it say, Julie?
Do you want to know what the rule says? The rule, as you all have,
Just rough it, you know it.
if the time for an online auction, online only auction with a fixed bidding time is extended beyond that fixed ending time, then the auction and the person conducting the auction are not included within the statutory exemption found at 1039, I'm sorry, and that the Auctioneer Commission's laws and rules would govern that auction.
I think we could discuss this till 5 o'clock this afternoon, and we'll still be in the same place we are right now.
But what you all are stating is this rule is written the way you have always read this exemption. Is that what I'm understanding, Chairman Phillips?
I'm still missing the connection between what we're writing and how it affects you. I'm missing something.
I'm going to have to get the public motor vehicle auctioneer's license in order to continue doing what it is that I'm doing, because I have been operating under the exemption.
I don't see how. But, I mean, I know you're a smart guy, Will, but you probably have got it figured out, but I don't know how that works.
I think what you all are saying is, from what you understand, that he hasn't properly been operating under the exemption. Is that what you're, I think there's two
If
different
there's a
readings
loophole
at
there,
play
I don't
here.
know what it is.
And neither do I, and I've never heard of it until today. I think that the law or the rules are good for me and they're good for Julie. And if we find a loophole, then that loophole is good for everybody in the state of Tennessee. But the loophole, I haven't seen it, I haven't heard of it. And I would personally like to leave things the way they are.
Thank you, Will.
You're welcome, and I meant no. I'm not here
Oh, I
to
understand that.
to tell you that you're doing anything wrong or right. I just want to make you aware that I don't believe I'm the only person who's operating under the loophole in the state, and I want to make sure that you're aware that you're getting ready to close a loophole, which you may have the desire to do that, and if so, it will leave me
If
in the
memory
position.
serves me correctly, we penalize somebody to the tune of $1,000 for operating an online auction and extending the time.
I don't recall that specifically offhand. Again, I have two commissions though,
It was
so
about 4 meetings ago.
I don't remember off the top of my head. I'm sorry.
Thank you, sir.
You're welcome.
Would the commission, by any chance, give me some kind of motion to the effect of what you all decided here? Because Mr. McLemore did come up here to make his comments. Is it just essentially what Chairman Phillips and Commissioner Morris said of we believe that the rule is, you all believe that the rule is drafted to state your interpretation of the statute as it currently exists? Would that be fair to say?
I think so.
That this is how you currently read the statute? This isn't a change, in your opinion? Okay.
That's my opinion.
I make a motion to leave it as it is.
Second.
Moved in second to leave it as is. All in favor, say aye.
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 Okay. Unless anybody has any further comments, that's everyone on my list. Is there anyone else that was intending to make a comment that didn't get a chance to? Okay. That concludes the comment period of this rulemaking hearing. At this time, we will continue with the economic impact statement and the statement regarding the projected financial impact on local governments for these proposed rules before the Commission votes to adopt the rules. I have included the considerations for the economic impact statement as well as the impact on local governments in a handout, which each of you have, along with recommendations, which I have prepared as a starting point for discussion as to each of the considerations. I gave you all a stapled packet of the notice of rulemaking hearing, and then there is also a memorandum from me to you all that is in the subject states economic impact statement. Do you see that? Okay. The commission will need to adopt responses to each of these considerations, which are provided for in the statutes, one at a time. I'll go through them. Like I said, I have included proposed responses as a jumping off point for discussion. You can feel free to disregard those, alter them, or if you find them acceptable, by motion adopt those, but we do need a response to each one. And the economic impact statement is being done pursuant to the Regulatory Flexibility Act, which is found at Tennessee Code Annotated, beginning at Section 45401. The first consideration that we have with regard to these proposed rules is the type or types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule, or in this case, rules. And we just need a response by motion from the commission that you feel responds to that.
I agree. I don't know what we're looking for here.
Need a responsive statement. I drafted one below that it's, I had drafted, these rules are not expected to have a measurable impact.
Okay.
It's basically an opinion, is it not?
It's what you all have, it's the commission's response to that statement. So as a group, not your individual
No,
one.
but that's basically an opinion. It's not, we're not attesting to that being a fact.
Right. I mean, I guess that it would be what you all feel is the most appropriate response to that. And I've drafted something that I believe responds to it, but if you all would like to do something different, this is the time for discussion and consideration.
Do we need to do them one at a time?
We do need to do them because I need responses by motion to each one.
Okay, I move that response 1, that the commission agrees with it. That there's
Would you
that
read?
There's not. I move that there's the type or types of small businesses identification and estimate at the number of small businesses subject to the proposed rule that would bear the cost or directly benefit from a proposed rule, that these rules are not expected to have a measurable impact on the cost of small business.
I'll second.
You did good.
Bonnie. Okay, the motion's been made and second. All in favor? Aye.
Aye.
Second consideration is the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record.
Proposed response is there are no projected reporting, record keeping, or other administrative costs required for these proposed rules.
I don't see, based on my review of them, that there are any required preparation of a report or record as a result of these.
Second.
Moved in second. All in favor? Aye.
Aye.
And that was that this proposed response be okay. The number 3 is a statement of the probable effect on impacted small businesses and consumers. And there is a proposed statement as a starting point of there is no expected adverse impact on small businesses as a result of these proposed rules. The proposed rules are expected to assist with the protection of the welfare and safety of the citizens of the state of Tennessee by seeking to further clarify provisions in the law regarding issues such as certain licensing exemptions and duties of licensees.
I move that there is no expected adverse impact on small businesses as a result of these proposed rules. The proposed rules are expected to assist with protection of the welfare and safety of the citizens of Tennessee by seeking to further clarify provisions in the law regarding issues such as certain licensing exemptions and duties of licensees.
Second.
Been moved in second. All in favor? Aye.
Aye.
Number 4 is a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business.
I move that there are no less burdensome, less intrusive, or less costly alternative methods known to which will achieve the purpose and objectives of these proposed rules.
Second.
Moved and second at number 4. All in favor say aye.
Aye.
Number 5, a comparison of the proposed rule with any federal or state counterparts.
Response to that would be there would be no known federal or state counterparts to these rules.
Second.
Moved and second. All in favor aye.
Aye.
Number 5 pass.
Number 6 is the analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule.
That's probably worded fairly. The wording in the response would be any possible exemption of small business from these rules would result in less protection for the citizens of the state of Tennessee.
Second.
Number 6 has been moved and second. All in favor say aye.
Aye.
I move that these rules are not reasonably viewed as having a projected.
Oh, I'm sorry. Did y'all vote on that one?
Yes,
Yes, we
ma'am.
did.
I'm so sorry. Okay, the last one then. Pursuant to Tennessee Code Annotated Section 45228, we just need to adopt a simple declarative statement regarding whether the rules may have a projected financial impact on local governments.
I move that we adopt a statement that these rules are not reasonably viewed as having a projected financial impact on local governments.
Second.
Moved and second. All in favor say aye.
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 Okay, now all we have left in this rulemaking hearing is we need the commission to address by motion whether it wishes to adopt the proposed rules. In this case, you've already made motions to make some changes based on a few of the comments. So what I would say is someone to have a motion to adopt the rules as amended here today, and then we will need to vote on that adoption by roll call vote. This is the only time we need a roll call vote. But
Make a motion that we adopt the rules as amended here today and has previously been addressed and issued in public forums, and with the comments that we've received today and made the changes to. So with the changes as adopted today.
I'll second.
It's been moved and second. We're going to have a roll call vote.
Yes, sir. Bobby Colson,
Aye.
Ronnie Collier,
Aye.
Adam Lewis,
Aye.
Jeff Morris, Howard Phillips.
Aye.
Motion carries, sir.
that concludes the rulemaking hearing today, and I'd like to thank everyone for being here. I don't know if the commission, we do have some other regular business if you all would like to take a break before then, but this does conclude the rulemaking hearing, and we can conclude the transcript at this point.
2-minute break.
We're going to take a short break.
All right, we have the video rolling.
All right, we're ready.
No, we don't yet. What happened to me?
Chairman, if everyone has reviewed the agenda.
Our airplane's tore up.
It won't use the pen.
Don't use a pen. You gotta have a pen. Yeah, there you go. Yeah.
It just,
Auctioneers and heavy
Right.
equipment are
I'm
not
telling
very
you, it's
good.
truth. You might as well put a jet airplane
No, you gotta
in
find
front of
library.
Library's up in that corner.
There you go.
Do I hear a motion to adopt the minutes?
The agenda.
The agenda, I'm sorry.
Okay.
I
The
so
agenda.
move.
Second.
It's been moved and second that we adopt the agenda.
I'm sorry.
All,
Was Mr. Morris the second?
Mr. Morris has made the motion, Mr. Colson second.
Is it? But I have Mr. Colson made the motion. Mr. Morris made the second.
That's fine.
Okay.
Do we,
Aye.
all in favor say aye. Aye. Oh, we need rulemaking hearing every day. Now, is there a motion to adopt the agenda? The minutes, the minutes.
I move that we adopt the minutes as written.
Been moved and seconded to adopt the minutes as written. All in favor say aye.
Aye.
Where we going now?
Okay. Next, we have Nashville Auction School. Russell Orr Hansen is here to provide us with an education provider update.
Nashville Auction School is now recognized
Thank
again.
you. Russell Hansen, Nashville Auction School, just to provide an update, our current newsletter, third quarter or second quarter fiscal year quarter newsletter is out. It's in print. I guess it's the first quarter. I get my quarters mixed up. But anyhow, we have a newsletter at the printers. It is being posted today. And it is available on the website currently. Also, we had a CE seminar in Johnson City on September 22nd. And we had 74 licensees attend and 4 staff members attend with their licensees. So we're seeing an increase in auctioneers bringing their staff with them, which is pretty cool too. We gave out evaluations. We had 71 completed evaluations, and we asked the question, how do you rate the facility? We had it at the Millennium Center at Johnson City, which is actually owned by East Tennessee State University and managed by them. It was an absolutely fantastic facility, and 96% of the attendees gave it a good to excellent rating. The overall quality of the program, again, 96% of the attendees that filled out evaluations gave a good to excellent rating. We also asked the question on topic relevance. We had Mike Brandley from the Ohio School doing a 2-hour program on ethics, and 94% of the attendees gave a good to excellent rating on the relevance of the program. And we had T. Kyle Swicegood from North Carolina presenting on salesmanship and professionalism, and 96% of the respondents gave a good to excellent rating. On the quality of the instruction by each instructor, 97% of the respondents gave Mike Brandley a good to excellent rating, and 93% gave Kyle Swicegood a good to excellent rating. So we had lots of great comments about going to Johnson City. We had a suggestion from one of the respondents that we hold all of our TAC seminars in Johnson City.
Right.
We also had a request that next time when we go to East Tennessee that we go to Maryville, and we take those seriously, so we will be looking to go to Maryville in the fall.
West Tennessee, that's what.
West Tennessee. We are in negotiation with the facility in Memphis this time, so we are looking to go there, and we're looking to go back into Nashville in the spring.
Where y'all looking at Memphis?
It is the it's the place that has the fountains. It's out by just the name is just gone.
Yes. About the Esplanade?
Yes, that's it. They're working
it's a very nice
for me.
Yeah.
So we're looking to go there, and
I know the owner. If you.
Yeah. Okay. Good. And then we are looking at a facility in Nashville for the spring seminar. We're just kind of
like the
jockeying
Esplanade.
dates.
That's nice.
Okay.
I
We
had
actually
several of
looked at
my
ones before.
guys attend the one in Johnson City, and they all said it was the best they had ever been to. They enjoyed it more, and they learned things that they, for instance, what's a hammer? I know that. And Johnson City is too far away.
Well, we'll be in Maryville next year, Commissioner
Awesome.
Phillips. So we appreciate
But Mike does a good job, doesn't he?
He does, and Kyle does a really good job as well. And we had participant feedback requesting a seminar in salesmanship and how to get business, especially in tough times, and he does a really good job talking about that on a lot of different levels for new auctioneers, for experienced auctioneers, for looking at different ways to do that, and how to present yourself in a professional manner to ask for business. So it was a really really informative and relevant seminar. So we will be repeating those. We certainly appreciate when commissioners come. If you come to the seminars, we will give you an opportunity to speak and address the group. So that's my report. Thank you. February.
Are we going to tab 2, legal reports? Is that where we're going?
Sir.
Julie?
Okay. Has everybody found it? Okay. The first 4 matters I'm going to present together. It's 2014-011-761, 2014-017-351, 2014-017-361, 2014-017-371. These are TAC open complaints based on information received by staff from the internet. Specifically, Respondent 1's website printout appeared to advertise a home located in Tennessee for absolute auction. At the time that the online advertisement was first printed, Respondent 1, now an actively licensed auction firm, as of on or about 6/19/14, was unlicensed with the Auctioneer Commission and the Real Estate Commission. When the complaint was first sent to Respondent 1 submitted a response apologizing for the confusion and stating that the website was launched before it was supposed to be launched, and Respondent 1 was formerly licensed in Tennessee but forgot to renew the license. As of the date of the response, Respondent 1's license had been processed, and 2 individuals, including Respondent 2, had become licensed as auctioneers. It was later noticed that Respondent 1's website had been changed to include the names and license numbers of Respondent 1 and its auction firm license number, Respondent 2 and auctioneer license number, Respondent 3 and Respondent 3's affiliate broker license number, and Respondent 4 and Respondent 4's real estate firm license number. Complaints were then opened against Respondents 2, 3, and 4. Respondents 3 and 4 submitted responses. Respondent 3 states that Respondent 3 was contacted by the owners of the subject property to list the subject property. Although Respondent 3 is unlicensed with the Auctioneer Commission, Respondent 3 has real estate licensure. When the listing expired, Respondent 3 states that the owners decided to auction the home and the owners met with Respondent 1. Respondent 3 states that Respondent 3 was contacted by Respondent 1 to discuss release of photographs taken by Respondent 3 of the subject property. Respondent 3 states that during that conversation, Respondent 3 was told that Respondent 3 would be the broker of record for the sale, but was told that Respondent 3 would have no responsibilities for the sale. Respondent 3 states that neither Respondent 3 nor Respondent 4, the real estate firm where Respondent 3 is affiliated, were involved with the marketing, advertising, promotion, or activities involved with planning the auction, and had no further involvement or communications with Respondent 1 regarding the auction sale. Respondents 3 and 4 state that Respondents 3 and 4 did not know that Respondent 3 and 4's names and license numbers were going to be used in the marketing materials. Respondents 1 and 2 submitted additional responses stating that after having several conversations with the Auctioneer Commission staff and the Real Estate Commission staff, Respondents 1 and 2 had believed they were compliant and later learned that the broker and auctioneer had to be the same individual. Respondents 1 and 2 state that, upon learning that this was the case, Respondents 1 and 2 immediately took action by contacting all advertisers to immediately cease promotion of the property. Respondents 1 and 2 state that the auction has been canceled, and Respondents 1 and 2 will no longer promote the property or auction until Respondents 1 and 2 are in compliance with Tennessee law. It appears from a search on Respondent 1's website that Respondent 1 and 2's statements regarding pulling the auction and advertising are true. Therefore, the recommendation is a letter of warning to each respondent regarding the provisions of TCA Section 6219-102. And I think, Commissioner Morris, you'd indicated you were going to recuse from this matter. Yes.
I thought the rules was confusing.
What?
I said, and I thought the rule committee
I'm
was
very
confusing.
sorry. I'd be happy to answer any questions.
Yeah, I mean, it looks
ultimate-
like to me that they forgot they were supposed to be licensed or something. It's that they was going to carry on till they got caught. To me, I'm just not sure that a letter of warning is quite strong enough.
Well, Respondents 3 and 4. Respondent 3 is a real estate licensee that is not licensed. Respondent 4 is that person's...
Would you repeat that, please?
Respondent 3 is a real estate licensee who is not licensed with the Auctioneer Commission. Respondent 4 is a licensed real estate firm that is also not licensed with the Auctioneer Commission. As you could see in their response, they were not listed initially on any of the materials. Later on, apparently, as the situation evolved, their names were included. They state that they were only involved in the listing and, did not have any participation in the auction, that they didn't put their names on the website. It was not, that their information was not found on their real estate firm's website, that they were advertising it separately anywhere else. It appears that Respondent 1 and 2, Respondent 2 is an auctioneer that is with Respondent 1, that it was on Respondent 1's website, and that they were the ones that had these materials that we kept receiving.
Does Respondent 1 have an auctioneer license?
Respondent 1 now does have an auction license.
But then?
A firm license.
He didn't at the time, all right?
It was expired at the time that this happened.
So he did not have a license at the time this sale was booked?
Not a valid license when it was initially listed. They reapplied for licensure, and that license was granted on or about June 19th. The second person is an auctioneer who was not previously licensed, I don't believe. The first license was obtained also on June 19th of 2014. And from all of our research following this, because I kept watching it as this all progressed, the auction was pulled and not held. We have no indication to the contrary that it was.
They had already advertised it, and then, oh wait, we hadn't got a license.
Yeah, they advertised.
No.
Did they pull the auction because somebody filed a complaint?
I don't know why. They say that when the matter was brought to their attention, it was pulled. Again, like I said, the matter was later opened against Respondents 3 and 4, just because when the advertising was amended on Respondent 1's website, their name suddenly appeared. We didn't know what their involvement was, so we sent complaints to them to see what their involvement was. They responded and said, hey, we were listing this. We were not planning to participate in this auction at all. This was not our website. We didn't put our names on there. So 3 and 4 were opened kind of subsequent to, well, actually 2 was opened subsequent as well, because initially that name was not on there as well. But Respondent 2, the auctioneer, is affiliated with Respondent 1, this auction firm. The other 2 individuals, 3 and 4, there's no affiliation there. They're a real estate firm that was listing the property beforehand.
I feel like Bobby that they probably would have went forth with the auction had there not been something said, and I don't know whether same as Bobby on this, whatever.
Well, you want to make a motion? Either one of you, please.
What more can you do than just a warning? Because I think they were probably planning on doing it anyway.
You can do a letter of warning. You can also authorize formal disciplinary charges and have a consent order. There is authority in your rules under your civil penalties rule to assess a civil penalty for a violation of 6219-102A1, which that provision states that you're acting or advertising or representing to be an auctioneer, apprentice auctioneer, or firm without holding a valid license. The range of that civil penalty is $0 to $1,000 for each violation. There's also a range for violation of 6219-102A2 of $0 to $1,000 for each violation, and that is conducting or offering to conduct an auction of real property unless the person is duly licensed as an auctioneer or apprentice auctioneer and as a broker or affiliate broker under the provisions of the Broker Act. So that's what's...
Well, we've seen this time and time again where, oh, I'm sorry, but if we hadn't got caught, we would have went ahead and done the auction and made money.
I move that we fine them $500 a piece, or send them a consent, or what can I do? A consent order? Or?
You can send a consent order, but I mean, is that for everybody? I mean, is that including this Respondent 3 and 4 as well? We have 4 different people here.
Yeah, for all
We
of
have the firm
them.
that ran it on their website, the auctioneer that is with that firm, and then we have these 2 other people that claim that they're not with that firm at all, and it's not their website.
I think we ought to get all 4 of them, if we can. I just really think they had larceny in their heart. If they hadn't got, from reading this, if they hadn't got caught, they'd have went ahead and had it and went on.
Boils down to you can get easier.
That's right.
So you're saying there's 4 or 5?
There's 4 people here. There's 4 in, there's
And
4.
a firm, which makes 5?
No, there's 4.
4.
The first one is what was the expired the expired auction firm. That's all. This information is from their website. They're the ones that were advertising here. This is respondent number 1 here. This unlicensed auction firm that later got an auction firm license, but last I checked, did not have real estate licensure and is the one that made the determination to pull it. Respondent 2 is an individual person that did not have a license of any kind to my knowledge until June, is affiliated with Respondent 1, the auction firm, and got an auctioneer license in June, but not any real estate information, not any real estate licensure to my knowledge, at least as of the time of these responses. Respondent 3 is a real estate licensee located in a different place than Respondents 1 and 2. Has been licensed with the Real Estate Commission prior to all of this, and is with a licensed real estate firm and had this
Number
listing.
3 was maybe trying to sell it privately or something before.
Respondent 3 states that they were listing the subject property before the owner contacted Respondent 1 to do the auction. This person claims, and Respondent 4 is that person's firm. Again, not the same person as the first one.
Number 3's firm.
Number 3's
The
real estate firm. Yes. And their response is, we were listing this property, and then these sellers wanted to have an auction, so they contacted Respondent 1. This
Sellers did.
The sellers
not
did.
the real estate firm.
They said that the sellers did that. The owners decided to auction the home, and the owners met with that Respondent 1 to auction. Respondent 3 and 4 indicate that they did not know that their names and information were going to go on Respondent 1's website, and they had no intention of participating in this auction at all.
So is it safe to say 3 and 4 got caught up in a bad situation that they had no plans to be involved in?
From the information that I've received, that's definitely what they're claiming, and that appears to be the case, because I did not see, I'm not making the statement absolutely that it didn't exist, but I did not see any advertising that looked like it was done on the part of Respondents 3 and 4 on their website or anywhere else that it looked like that they had posted that information or intended themselves to look like that they were conducting that auction. Now that's a little bit different than with Respondent 1, because it was Respondent 1's website where this information was pulled from.
So the real estate agents and firm 3 and 4 very good job advising our client.
You gotta decide who's telling the best tale.
The 1 and 2, or A and B, which did you call them, 1 and 2?
1 and 2.
1 and
You can call 'em
2
what you'd like.
had no license whatsoever and booked an auction of real property. That's where we're at.
I would like to, and ask me Tim if I can do this or not. I'd like to find 1 and 2.
Each.
Yes.
Okay.
The firm and the individual.
Okay.
I would like to send 3 and 4 a letter of instruction.
Okay.
That they should, in the future, look to see if someone that one of their clients or they hire to conduct an auction is licensed.
And probably include
By
the
the Real
provisions
Estate Commission
of that.
and the Auctioneer Commission.
So in the future, look to see if a client hires someone to conduct an auction that they're properly licensed.
Right.
Is that a motion?
Let me just clarify a little bit.
Yes,
You said $500 for Respondent 1 and $500 for Respondent 2, and the violations there would be
Unlicensed activity.
62-19-102 A and A1 and 2, including both of those provisions. Okay, I'm clear on what you want. That's within your authority to to authorize formal disciplinary charges based on a violation of that statute, and then have these consent orders contain those terms. You're also free to do letters of instruction when you believe they're appropriate, like you did for respondent 3 and 4. So
I put that in the form of a motion.
You mentioned two things that they, what are those two things that they did that broke the rule?
well,
They weren't licensed.
One, they weren't licensed.
it's both included within 6219.
Okay, well, what about soliciting an auction without a license? That's against the rule too, right?
Number 1 is, do you have a copy of the statutes? Because I can read it aloud again, but 102A1 talks about acting or advertising or representing to be an auctioneer, apprentice, or firm without a license. Number 2 talks about conducting or offering to conduct an auction of real property unless the person is licensed as an auctioneer and a broker, as an auctioneer or apprentice, and as a broker or affiliate broker. Those are the two violations that are found at 6219, 102. A1 for the regular auction requirement, A2 for the real estate.
3 and 4, we're trying to sell the property, and 1 and 2 comes in going to auction it, right?
Yeah, but supposedly the seller went straight to the
Seller
1 and
went
2.
straight to 1 and 2. Well, I think I'm with
Mr. Lewis,
Bobby.
did you have
Are
a question? I thought you did. Did you have?
Well, no, I just asked if that was a motion that
Bobby
he had.
made
Oh,
it.
okay. I'm sorry. I didn't know. If
But
it
I
was-
do have a question. What long, aside from the $500 fines, help me understand what long-lasting effects do these stay on their record? Do they go away after a period of time?
This would be on their disciplinary history, and it also within all of our consent orders, this is limited to these facts right here. It also would be, there's a provision in there that they should cease and desist from any violations that are, if they sign the consent order, they are admitting that the facts as outlined that would be restated in the consent order are violations of these listed statutes that we just referenced. And by admitting that, they would also be agreeing not to cease and desist any further violations of this type. So if these two people went on to do this again, they could be disciplined further. This is limited to this. This is a disciplinary action. They're authorizing disciplinary charges, which would ultimately turn into a formal hearing where the commission could take further action there. They're offering them this consent order that if they agree to it, to sign it and pay this amount and agree to abide by the rules going forward, it would end this matter informally at that point. And it would go on their disciplinary history if someone were to ask, had they ever had violations before. It would also be considered if this commission were to get a second complaint of this type against these people. They would see that they'd had this before and possibly consider more aggressive or more a higher penalty, for example, next time. It's considered if another complaint of this type is brought into our office down the road. But no, if they sign the consent order, that would go on their disciplinary history. If it goes forward to a formal hearing and the commission finds against these people, it would also go on their disciplinary history. If for some reason this went to a formal hearing, they didn't accept the consent order, it went to a hearing, and for some reason the commission found that there was not a violation, that would likewise go on their disciplinary history. That's how it would be reflected. At this point, the commission's authorizing charges to be filed and offering these respondents the matter to resolve the matter informally without a hearing by paying $500 and signing the consent order which admits to the violations under these facts. Or they can go forward to a hearing.
There's been a motion made. Is there a second?
I'll second.
Motion been made and second to, let's see if I got this right, send respondent 1 and 2 a fine of $500 each.
Consent order, $500.
Consent order, $500 each. And 3 and 4, a letter of instructions. Is
A
that
letter
correct?
of instruction regarding 6219-102 and ensuring that in the future they look when their client hires someone to be sure that they're properly licensed. Is that correct? Okay.
All in favor, say aye.
Aye.
Aye. Unanimous.
Just as a note, the record does reflect that Commissioner Morris recused himself from this
He
matter.
didn't vote.
The only other matter I have on here is 2014-017721. Complainant alleges that respondent, auctioneer, is an apprentice and respondent's sponsor, auctioneer, was not present during the sale. Complainant states that respondent did not bring the items up front and they were not placed on the TV screen because it quit working, which usually generates a better price. Respondent states that complainant did not finish selling small items before moving on and rushed through the sale. Complainant further states that respondent began auctioning floor speakers at $2 and complainant's son called out to pull the items from the auction because they did not want to give them away, and respondent later stated later that the complainant's son was banned from respondent's auctions. Complainant states that respondent had an auction earlier that morning without complainant's sponsor. Respondent states that respondent has a great relationship with the complainant, who is a consigner, and states when respondent heard complainant was unhappy, respondent attempted to contact complainant but not receive a response. Respondent states that the sponsor auctioneer was previously respondent's sponsor, but respondent received an auctioneer license earlier this year and respondent is no longer an apprentice that requires the presence of a sponsor. Respondent further states that respondent was having trouble with the internet connection to place the items on the TV screen, so the items were held and displayed for buyers to see. Respondent states that a buyer asked about some speakers, to which it was responded that the starter bid was $2, but the complainant's son yelled and said that they would not be sold. Respondent states that each auction brings in a varied amount of money, and complainant feels this auction brought them less money than normal. Respondent states that complainant brought the least amount of items to this auction, and this auction had the least amount of buyers checked in, but this auction did not bring in the least amount of money. Respondent states that respondent spoke with complainant after the auction about complainant's son's behavior, and respondent stated that complainant's son could not behave that way at a family-friendly auction. Respondent is disappointed that complainant is unhappy with the auction, but states that respondent provided proper services. The recommendation is to dismiss.
Well, you had an apprentice auctioneer doing an auction without the presence of an auctioneer.
No, that was what was alleged. This respondent states that this respondent states that they were formerly an apprentice but were fully licensed as an auctioneer prior to this auction taking place. And from our records, Ms. Whaley looked it up. I'm not as proficient in our regulatory board's licensing system, but that appears to be the case, that this person had a full auctioneer's license prior to the time of this.
I misunderstood.
I'm sorry, and that was it was an allegation, but based on our records, it did not appear to be the case when checking with her, and based on what this respondent's response was. Mike.
You able to call him and talk to him and find out what was really going on?
With the auctioneer or
Yeah,
with the
with
respondent?
the son and all that. I mean, he had a bad day at the auction, but that happens.
I believe that the complaint. The response or the complaint, one of the two, mentioned that the gentleman's son is, and that was the response for the outburst. It was not just someone behaving badly or just choosing to be disruptive.
So but they'd done business before together, right?
Yes, they both indicated that they had done business with each other for several years. And yes, we did confirm that the auctioneer had upgraded, I believe, almost a year prior to the date of this sale, and he was a fully licensed auctioneer.
I move we go with legal's recommendation.
Second.
Moved and second to accept legal's recommendation. All in favor, say aye.
Aye. Which was to dismiss.
Which was to dismiss. We got a lady doing shorthand here today.
That's all I have for this month on the report. Ms. Whaley has some.
Yes. Next on tab 3. Yes, tab 3. And I can provide you with the highlights if you don't want to open
I don't
it
like
up.
my touch.
You don't have any electricity in your system.
I don't have.
What you have before you is basically a summary of the open complaints that the Commission has currently. And you'll notice there are 58 matters, and I believe last meeting Mr. Morris had inquired how many of those are newer matters, because we do have an outstanding caseload of 36, which are all tied up in one matter. So really we have 22 open matters currently, and several of those were presented today. Currently, the performance measure, we are doing very well compared to the department standard of 80%. We're at 93.75%, and that is referring for legal action complaints within 180 days of receipt.
How long does it normally take from the time a complaint comes in until it comes before the board?
It varies because sometimes we require investigation. We have several matters that are investigation right now, and I'm waiting to get an investigator's report back on those. That's not always required, and so sometimes, such as, one of these, some of these today, I was waiting to watch that auction to see how it played out. The second one, there was really no investigation needed or any time waited to present that, so it really varies.
And sometimes matters, we receive a complaint matter, and then we will receive secondary information that needs to be considered alongside. So. All right. The final item is related to the Auctioneer Commission's testing contract. I guess a year ago, we brought before you to extend the contract to the 5th year. And we are currently in the process with our legal division to in the process of preparing to submit a request for proposal. And this would be for the Auctioneer Commission's testing contract for your auctioneers, your apprentice, gallery licenses. So what we're coming before you today is to ask and get the Commission's opinion on. We can issue the RFP with a contract period of 3 years with 2 extensions, or we can simply issue it for 5 years. And Julie, please feel free to chime
to you in the past. I wasn't here when the last one was issued, so I don't know why the determination was made to do it for 3 years with 2 optional extensions. The way that our contract attorney that's in the legal division has stated to us, there's, you can do it one way versus the other. I wasn't here at that time, so I couldn't speak to the reason as to why the current contract was done with the term it was. Or you can do a flat 5-year contract. Sometimes they said that can increase the number of bidders because, it's a longer contract. I believe probably usually the reasoning behind doing a 3-year with a 2-year possible extension is if there are any problems with the person who wins the contract. But like I said, I wasn't here 5 years ago when you all, not even when when any of you maybe even were on the commission. Mr. Colson might have been on there at that time. It's just if you all want to keep the same term, we can let them know that. If you would like to change it to 5 years, we can do that as well. I just couldn't speak to your reasoning behind the way it was currently
This is
drafted.
going to be put out for bids, is that what it is?
Yes, this is the portion that will be distributed out, and people will be able to respond to it and bid.
What would be better?
My recommendation is we go with the 5-year term if we can get a little bit better pricing on it.
Actually, this contract is a no cost to us.
It would be for the
fee,
testers,
the
though.
fees.
Right, I understand
all
that.
that
But,
take
I understand. I think it's-
but
Yes, I just wanted to.
by the same token,
especially
but
for
if
Mr. Lewis's
you can
benefit.
get a little bit more competition in there for whatever whether it be the testing costs or what have you, get the testing costs down. 'Cause I think they charge $125 every time somebody walks in the door. But anyway, I'd recommend to do the 5-year term.
We have a motion to go to a 5-year term. Is there a second?
I'll second.
Moved in second to be a 5-year term. All in favor say aye.
Aye.
Aye. And now I have a question. An apprentice auctioneer has to fill out a logbook, as everybody's aware. And I don't know who sees this logbook, but I would make a suggestion that some way it be brought before the commission before they take their test.
Every applicant we have for an auctioneer's license.
Every apprentice that has to keep the log. What happens to that after he keeps it? Where does it go?
It is submitted to the office, and we review it to ensure that they meet the 1,000 hours.
The 1,000
1,000
points.
I mean, 1,000 points, I'm sorry.
As outlined in that
Sorry.
rule.
Yes, as outlined in the rule.
That's how it's been done to my, because I don't even typically review them. The office does to see if they meet the requirements of the rule, and the rule is pretty specific. So, I mean, I can look into seeing if we can bring them before there. I don't know if that
I wouldn't mind looking at them too. I just think there's not that many, is there? I mean, during the course of a year.
It varies probably 2 to 3 a month. Now,
And-
this will, this is just one thing to keep in mind. If someone submits one today, it will be they will have a 1 month waiting period. Because
Yeah,
I
that's a good-
I
that's a
cannot
good
approve
point.
their license without you reviewing and approving it. And for instance, if you were if you met in June and you don't meet again to August, there's automatically going to be a 2 month waiting period. It's just I'm not trying to.
That's
I
why we
just
would
wanna-
just need to check into it.
I
is
just
all.
want to bring that point.
Well, I know
forward.
how anxiously they're waiting to get their license, so I don't want to do something that would hold them up for a month. So,
Just for the heck of it, could we maybe get a couple of old ones that maybe somebody's already passed, got their license or whatever, just for the heck of it, I just kind of look at them, I just kind of like to look at a couple of them, just see what's there, you know.
Absolutely. The log is actually, it's very simple. It just asks them to
the
detail out what
reason
they've
that
done.
I'm concerned is I know for a fact of more than one apprentice auctioneer that probably never went to an auction before they got their license. So, I mean, you can get.
And this responsibility falls to the sponsoring auctioneer who
They actually have to sign.
The
every-
auctioneer has to sign off on, he initials each line item, and then, of course, he's signing off on the
I
totality.
understand all that, but what I said is true, and the auctioneer signs off on it. I think if that was just a little bit,
Well, we wouldn't have any way to confirm or deny it.
no, I know.
I mean, and I am more than happy at the next commission meeting to put this on the agenda for you to review the apprentice logs, and I can bring you the form and
Yeah, I'd like to look at it.
a
just-
few other logs.
It's been a long time since I've even looked at any of this stuff.
That is absolutely, and we're always trying to update the forms and keep them accurate.
The reason I got this on my mind, I have an apprentice auctioneer, and he is the biggest go-getter I've ever seen, and every Monday he's bringing me one of these things to sign, and I got to thinking, well, so-and-so never said anything, you know. So it just needs to be something that's done correct.
Absolutely, I will bring the logs, and we'll have the rules that break down how points can be earned by apprentices.
Any other business?
I think you had one of there was one there. That was it then. That was, if that was all.
Not yet.
That is all, and as promised, it is noon.
1 o'clock.
Yeah, your time it is,
Yes.
you're right.
We are currently in Central Time.
Ain't happy if you don't live in the real time.
If we could, motion to adjourn?
I move we adjourn.
All in
Second.
favor, get up and leave.
Julie, don't you have that baby before next meeting? Now, we need you.